15. 2 days. I have some difficulty in the second half, so could it be a little bit upgraded? Maybe after item number 5, it can be taken.
Okay, we'll try to. Okay.
Deeply obliged.
May I please, your lordship, my lord, I beg to mention for my lord listing of for withdrawal, my lord. It's possible, my lord, behind the bar, so they want to pursue before the trial court, my lord.
All mentioned before the court number 18.
Item number 1.
Lordship, in this case, charge sheet has been filed. Three persons or witnesses examined, including the victim. The case has been established under section 6 of the POCSO, along with the 142 and 3 within bracket 5 BNS. And my ground is that the reasons of arrest is not assigned to the accused petitioner. That is the reason. That is the ground of my.
But it is a POX.
The FIR name accused are connected with a banned organization, ULFA. They were arrested. Subsequently, these 3 people were given bail. The FIR is at page 18. If I'll just read. With reference to the subject cited above, I have the honor to submit that reliable and actionable intelligence has been received from a credible source indicating the presence and operational activities of certain overground workers or linkment to the prescribed organization ULFA Independent ULFA 1 in Guwahati. As per the input, these individuals have allegedly established a covert base in the Guwahati city with the intention of orchestrating subversive and anti-national activities, including but not limited to waging war against the state. In furtherance of the objective, the said benefit outfit. The information further reveals that the aforementioned individuals are directly associated with James Asong, a self-styled commander of ULFA, and are reportedly engaged in the collection of illegal funds through extortion. These funds are believed to be utilized in supporting and facilitating the operations of ULFA, so and so, and in the lights of sensitivity, subsequent inquiry technical details, and they found just page 19, 3 people. Now, as per the FIRs, there very strong words has been used, but in the FIR, but in the CD, they didn't find anything, and subsequently, all these 3 people were aliens.
These three.
Huh?
These 3 are enlarged on bail.
Yes, that is at page 23. Minutes. Kindly go to minutes. Page 24. In the FIR, it is, I'll just read from para 3. In the FIR, it is alleged that some overground workers of an organization called ULFA have been collecting money within the city of Guwahati, and to that effect, they have created a mentor. It is also alleged that the overground workers of the banned organization has been led by James Asong.
Now, your petitioners are not those 3 petitioners.
No.
So you are?
I have been arrested on the, after that, they again arrest one Tapan Roy. On his statement, I have been arrested. Now, this Tapan Roy has also been given bail, enlarged on bail. Well, here is the bail order. On the motion day itself. On the length of detention. On 55 days, he was given bail. On his statement,
Now, your petitioner is in custody since when?
48 days.
Yes, Sharma. Now he is saying that he did this. How many petitioners you are representing?
Only 1 minute.
1. He is basically arranged only on suspicion, and others were already granted bail in that connection. But
Also, the perusal of the CD will be required also because EAP Act is there. So, Lordship will fix it after vacation, Lordship. In the meantime, Lordship will go to the CD and see what his links are, Lordship. Otherwise, he is involved, Lordship. It is mentioned in the forwarding also. So, let the CD come, Lordship, because it is under Unlawful Activities Act, Lordship. It's a very stringent act, and there are some restrictions also there in that act, Lordship. And all these orders were passed after perusal of the case diary. So, at least Lordship will peruse the case diary.
On the case of Tapan Roy, his statement I was alleged to as arrested, that was passed even without looking at the CD.
Obviously, most probably considering the length of detention, I think. It was almost 90 days. Maybe.
May kindly produce minutes. Page 2.
Maybe.
Maybe.
I don't know, but I don't find it proper to pass any order without perusal of the case diary. Let it be on. So immediately after vacation, can it be fixed? 18.
18.
We are fixing it on 18 immediately after vacation.
10.
That's what we are not going these two listings. We are not bothering the vacation court. If registry is there, then they fix, they may fix. Otherwise, I'm not on the 18th of July. That's list on it. Three people. Yes, item 3.
May I please your lordship? There has been a matter under section 409, 468, 467, 120B and 420 IPC. Your Honor might kindly peruse the FIR that is on page 14 that we have annexed with the petition. It was launched by the manager, Canara Bank, Bongaigaon branch. I am duly authorized on behalf of the bank to lodge FIR complainant in the suspected fraud case in 774 KCC borrowers who availed the KCC agricultural loan amounting to 7,000 crore approx. Fraudulently by submitting forged documents and misappropriate the public fund loan proceeds intentionally. The list of borrowers culprits who perpetrated the fraud in collision with one BC agent named Mrs. Dhoritri Kalita, who is the petitioner in this instant case, your lordship, is in annexure 1. Now, your honor, the fraudulent transaction is found to be occurred from 1/1/2012 to 7/6/2024. We have also furnished list of staff posted in the same branch during the period of occurrence of fraud as annexure 2 for your information only. Now coming to the forwarding and the grounds of arrest on page 22, your lordship. During interrogation, point 2 of the ground of arrest, during interrogation, sufficient evidence found against the arrested accused person, and she has misappropriated about 7 crores in the name of KCC loan. Your honor, my humble submission is that she is a BC agent, your lordship. A BC agent's role is to gather clients for the bank, and the clients, on availing the loan, they go to the bank and they are taking the loan. So she is an agent, your lordship. She 409 clearly speaks that two essential ingredients of criminal misappropriation are misappropriation and entrustment. There the ingredients are clearly missing, your lordship, because she is merely an agent. BC's role is to explain to the villagers about the schemes. After that, the villagers go, the clients, they go to the bank, and it's the duty of the bank to make sure that proper documents are submitted. The bank, on the basis of verification, issued loan. And your lordship, a pertinent point that I would like to state here is that, your honor, from page 15 to page 19 are the list of borrowers, which is only from 2016 to that of 2017, your lordship. My client, she joined services on 2018 as a BC agent, the debt collecting agent, your lordship. So she is nowhere involved with the aforesaid. They have alleged, and why are the bank officials also not made like in the paras written in the annexure 2? This is for the information only. But can it be, your lordship? She is a permanent resident of Bongaigaon. Her statement has been recorded. So why is detention necessary, your lordship? From 7,000 crores on investigation, it is found out it is 7 crores. And then, and statements have already been recorded. She joined in 2018, your lordship. And her role is limited to that of connecting the bank and the client. So how she has been arrested, but the one who are actually behind, she's being a mere scapegoat to this, your lordship. So my humble prayer is that since she is already a resident of the same locality in Bongaigaon, she's not directly also involved in the case, she will cooperate with the investigation and no chance of absconding. Your honor, your lordship might be granting her the privilege of privilege of bail, your lordship.
Yes.
Yes, also she was arrested on 14/6/25. So today is probably 16 days. And the offences alleged are lordship 409 and 467, which are 90 days lordship offences. And if lordship kindly comes to the forwarding at page 22, just for an analysis. Page 22, lordship, the grounds of arrest, lordship will see. Second point, during interrogation, sufficient evidence found against the arrested accused person, and she has misappropriated about 7 crores in the name of KCC loans. Next point, lordship, the arrested accused person have used the documents of villagers for opening loan account without the knowledge of the villagers. Third point, the arrested accused person also used court's documents for opening bank accounts for sanctioning KCC loan. Thereafter, Lordship will kindly turn to page 24, Lordship. Should I say, Lordship, page 25, Lordship, comes. Second last paragraph. After perusal of the case diary, what the learned court below has observed, Lordship, as per the FIR, 774 KCC borrowers availed KCC loans to a huge amount fraudulently by submitting forged documents. From the case diary produced by the IO, it is seen that the IO has gathered material showing involvement of the accused in submitting such forged documents of customers to the bank for sanctioning of KCC loans and thereafter misappropriating the sanction amount. Considering the implementing materials again in the case diary, the accused as the matter involves an extensive investigation as the same involves misappropriation of huge amount of public fund. It was not granted, Lordship. So, Lordship, this is very initial stage of investigation. Case diary may be called for, Lordship.
Considering, if I may submit, your lordship, the ingredient of forgery and forgery, these two are the only sections for which 90 days has been sought. So the basic two sections, that is of forgery, 468 and 469. 468 talks about, 467 talks about with trust to wills and. But the forgery, in order for me to forge something, your lordship, I have to be directly involved with this. I go and tell the client.
See, as per allegation, you are directly involved because you are from the villages, you have taken some documents without their any knowledge, you have opening some accounts in the name of KCC loan and thus you have misappropriated a huge amount of money at least at the time, prima facie 7 crores as per the thing.
As per.
So it's not a case that you have not involved. Prima facie is there. And obviously, she is as you have submitted that she is only a DC agent, maybe.
Yes.
He may not be, she may not be directly a bank employee or not. But the question is that definitely she was there as per the preliminary investigation. So I think perusal of the case definitely will be necessary for passing any order. Okay, we are fixing it immediately after vacation. We'll try to fix it by
23rd, Lordship.
your
16.
petitioner is in for 14.6.
Yes, your
14.6.
16.
16 CD may not be 16 can be, Sharma. Okay, then 16 because she is in custody. Oh, yeah, 16. 16, 7. We do things. Okay.
Oblige. I have thought.
I do that from you.
Regular bail application, my lord. 138 is behind the bar, my lord. Kindly see page 10, my lord, FIR, my lord.
138 is a POXO.
My lord, sir.
That speaks about causing hurt by means of poison, etc., with intent to commit an offense. 127, that is of wrongful confinement. 71, that is of gang rape, and 61(2), that is criminal conspiracy. And my lord, in this particular case, my lord, 4 accused persons were arrested, my lord, and three of the arrested persons have been granted bail by the coordinate bench of this honorable court only on the ground of length of detention. One at 30 days and another one at 47 days, my lord. My lord, I have enclosed the, my lord, the bail granting order, my lord. It starts from page 22. And also, my lord, in this case, my lord, the charge sheet has been already submitted, my lord. So my further custody interrogation may not be required, my lord. And other persons, my lord, also already granted bail, my lord. So I am on parity, my lord. My lord, may kindly see page 22, my lord. It's a bail granting order to one Gopal Subba. And lordship may kindly turn page 23, paragraph 6. Mr. So-and-so submits that petitioner has spent more than 30 days in judicial custody and under the given circumstances, the period of detention of the petitioner should be taken as a ground for releasing him on bail. I have considered the submission made by the learned counsel for both the sides. Without expressing anything on the merit of the case, this court is of the opinion that the period of detention of the petitioner should be taken as a ground for releasing him on bail.
Accordingly, my lord, paragraph 9, my lord, he was allowed to.
Yes, Sharma, 3 of them have already been granted.
Lordship,
bail.
but that was in the stage of investigation. Now, Lordship, charge sheet has been filed. So Parity will not come. So Lordship will come to call for the records.
My lord,
Lordship.
already, my lord, charge sheet has been submitted, my
Yes,
lord.
that is
Whatever I
the
have
check.
placed, my lord, that will come only, my lord.
Cannot be Lordship.
I have enclosed the charge sheet also. I am not on the, my lord, not on the, my lord. I am not saying that I am not involved in this case or, my lord, that sort of submission I am not going to make, my lord. There's already, my lord, I am behind the bar and nothing will, my lord, survive me if I am remain on, my lord, custody, my lord.
Lordship, this is
Yes,
regarding
sure.
rape, Lordship.
But
This is regarding gang rape, Lordship. So it's a very heinous offense, Lordship. So at least the perusal, the records will have to be done, Lordship.
My lord,
Otherwise, without those orders will have been passed after perusal.
But from 2019, they started and they filed an application before the concerned Ministry of Petroleum and Natural Gas to diversify its activities in retail outlets of the petroleum products. So initially it was for gas only, but now they have diverted their business and wanted to do business just like IOCL, HPCL, BPCL. In that manner, they want to expand. For that, they have to apply to the central government, and central government has given them authorization, permission to expand their business in the field of retail outlet of petroleum products. That permission was granted in the year 2020, which Lordship will find at page 43. Page 43, Annexure P2. Application of Assam Gas Company Limited for grant of authorization under the resolution dated 8/11/2019 for retail marketing. So in the retail marketing, they wanted to expand their business. Here, Lordship will only note 2 clause number 3. The applicant and its dealer would abide by the marketing service obligations and retail service obligations as notified from time to time. It will set up at least 5 retail outlets in remote areas. The time frame of setting up of the outlets would run concurrent with the total plan. So they have applied for a certain number of retail outlets throughout the state of Assam, and out of that total amount, 5% of the retail outlets should be established in remote areas, not near the highways. And it has to follow the principle, the policy guidelines of 2019. And according to the 2019 guidelines, 5% of the retail outlets, the overall period is to complete that 5% is 5 years period. But at the end of 3rd years, they must have at least 20%. And at the end of 4th year, that should be 50%. And at the end of 5 years, it should be 100. So in case of Assam, about 120 petrol pumps were allotted by this authorization letter. And in respect of that, 5% will come to about 6 number of petrol pumps in remote areas. Out of which, at the end of the 3rd year, we have to have 2 numbers. At the end of 4th year, we have to have 4. And at the end of 5, we have to have all 6 petrol pumps in the remote areas. To ensure that, we have to submit a bank guarantee. Against each petrol pump, we have to submit a bank guarantee of 3 crores. So for 6 petrol pumps, we have to submit bank guarantee of 18 crores. So that is the basic policy. Now, after the authorization, which came on 21st of December 2020, the state government has to give a approval. That is called Public Investment Board. PIB approval has to be granted by the state government, and that was granted to us on 12/11/2021. That Lordship will find at page 56. So approval dated 12th of November 2021, office memorandum subject approval of PIB for investment of 539.74 crores by Assam Gas Company Limited for setting up of an integrated fuel retail network with 120 integrated fuel retail outlets across Northeast India under company-owned, company-operated, COCO and dealer-owned, dealer-operated model. So for that, the amount has been granted, that is 539.74 crores. So after that, we have to actually start the process of floating the tender, who will be bidding for having this dealership. So thereafter, we floated the tender in the year in 2021 itself. Sorry, it was on 1/2/2022. AGCL issued the advertisement inviting applications from interested parties for dealership. Last date of submission of application was 15th March 2022. Lordship will find that also. That is not we have annexed, we have stated that. Thereafter, the actual work started, and till now we have 66 number of outlets which will be ready for commissioning within next 3 months to 6 months period.
66.
66 out of 120, and out of this 126 number of these remote area petrol pumps also are almost ready, which Lordship would be pleased to look at our writ petition where we have annexed. It is at the final stage of completion. Photography lesson. Yeah, good photograph. I got not yet. Status of remote area that Lordship will find at page 65. I think Lordship is having colored photographs. Page 66. So 6 number
Yes.
of petrol pumps, these are at the final stage of completion. So in next 3 months to 4 months period, these all will be functioning. All
These are in remote areas.
these are in remote areas. These are regarding 6. But the policy says that at the end of 3rd year, we have to have 2 completed. At the end of, sorry, 3rd year, 2, and at the end of 4th year, there should be 3. And at the end of 5th year, that is the present situation is going on now. We have the normal 5 years course till December 21st, 2025. 5 years period will be completed. But we
December
have failed.
2025.
25. Still 5 year periods, we still have 6 to 7 months left. The problem is that we have failed to complete the these outlets in the remote areas at the end of 3rd year and 4th year. But the reasons are very genuine. It is not a case that we have failed. In fact, we have received all the permission, etc. But that took time. So we have 5 major reasons. Today, as it is a vacation code, I would not like to trouble your Lordship with too many facts. Why we are delayed for completion within the 3rd year and 4th year's target. The first reason was that the PIB approval, which I have just placed, the government approval, that took about 1.5 years. Then next one is that 2.5 years we lost due to COVID. Because our permission was granted in the month of December 2020, that was at the height of COVID. Then the COVID-2 came, and COVID-2 take also almost more than 1.5 years. So till 2022, the 2022 end, there was extremely difficult situation, not only in the normal courses, but in respect of other activities where we have to go to various remote areas. There is a lot of restrictions in traveling, etc. Lordship knows, I don't have to. Even the Supreme Court allowed that all these limitation things would go away during the COVID. About 3 years leeway was granted to everybody, for the court as well as to the litigants. So here also we lost 2.5 years due to COVID. Then there was 1 year delay of the PIB approval. And third major problem was that there was in remote areas, lot of lands were belonging to agriculture category. The classification of land that has to be converted to commercial activities land. So those things also delayed our project, as well as because in every conversion there has to be LAC meeting, land advisory committees meeting. Those meetings also took a lot of time, because in those meetings the members belongs to MP and various other public representative government officials. So during that COVID period, there is a delay of holding this LAC meeting. In fact, in Assam, about 2 to 3 years, there was no LAC meeting during that period. And finally, in Assam, Lordship also knows, because some of the petrol pumps in these areas remote are flood affected area, and heavy rainfall was there last year. Last year, flood was in Assam was unprecedented. Every year we have flood, but last year's flood, it was about a spell of 3-4 times flood came. So all these things, all these factors played a major role in getting us delayed. But we are not saying that we'll cross 5 years. Within 5 years, we can complete. And we have already placed the documents also with photographs where we can very easily say that 70 to 80% work is already completed. Not only in respect of 3 or 4, it is in respect of all 6. So my humble submission is that they have issued what is the impugned order? The impugned order they have issued recently on 28th of this month, where they have page 63. Because against 6 number of these retail outlets, we have to deposit 3 crores as bank guarantee. So they want to invoke this bank guarantee in respect of 3 numbers. That means 3,339 crores by this letter dated 28th June 2025, where the concerned ministry, central government ministry, that is Ministry of Petroleum and Natural Gas, they wrote to the branch manager of Indian Bank, which bank had granted the bank guarantee in favor of us. So this letter, it is challenged here, Lordship. They want the subject, Lordship will kindly see, partial encasement to the tune of 9 crores out of 18 crores of BG number so-and-so dated 28/1/2021. So this bank guarantee was also given after almost a year. So the department also was not very prompt that immediately they took the bank guarantee. And bank guarantee period is up to December this year, and it is encaseable for 1 more year. That means till December 2026, bank guarantees are always in favor. Now, what is the law relating to? Here they say that they want 9 crores encasement by the central government. And if that is allowed, then we will lose this 9 crores forever. There is no scope of, even if we complete all the projected works by the December 2025 also, this amount will not come back to the state of Assam. So for that, this bank guarantee is valid up to December 2026, during which the central government can always encash it if we fail to fulfill our targeted work within that stipulated period. And in the meantime, also, there is a change of policy in 2021 also, out of which there is a drastic change, which is not indicated here. Our whole work was allotted in terms of the 2019 policy. That policy says that 20%, 30%, and 100% within that time period of. So we have to complete all the work. At the end of 5th year, 100% work has to be completed. Now, this impugned order has been issued where they sought an invocation of this 9 crores out of 18 crores from the bank immediately without following due process of law. They have not informed us. In between, Lordship, in 2024 as well as this year also, we wrote twice to the ministry to give us extension of this period. Till now, they have not responded to our request that kindly give us extension. And these are the grounds for which we want seeking responses. Without disposing of our applications, these are part of the records, Lordship. They have issued this impugned order by keeping us at dark, number 1. First, that they have violated, they should have disposed of both our applications for seeking extension. They have not touched it. Number 2, before issuing this impugned order, they should have given us a notice that you have failed to do this within that stipulated period. So we are seeking invocation of your bank guarantee at the tune of 9 crores. That notice has also not come to us. So these are the 2 grounds which I am relying upon for seeking an interim protection. On top of that, the law is well settled regarding invocation of bank guarantee. Bank guarantee can be invoked anytime by due notice, but the Honorable Court would like to interfere in 3 situations. The first situation is that if there is a fraud. Our case is not on fraud. The second cause is, Lordship, 3 grounds. Second ground that the Delhi High Court, which has been upheld by the Supreme Court, also says the second exception relates to first is fraud. Second says the second exception relates to cases where allowing the encashment of an unconditional bank guarantee would result in irretrievable harm and injustice to one of the parties. So in this case, if this amount is taken, it will cause irretrievable harm to us. Number 3, the policy itself says that there should be assessment of the loss. How can they assess that 99 crores has to be encased? Because we have completed more than 50% of the work. They have to first assess it. If we had not taken a plot of land in a remote area and not established a retail outlet there, that would have been 100% loss to them. That means we are not going to the remote areas, only concentrating in the urban areas as well as the commercially viable. They want equitable distribution of the petrol outlets throughout the state or the region, Northeast region. That is why to ensure that this bank guarantee is taken. But what we have done, we have procured land, we have appointed dealer, we have undertaken the work, 60-70% work is completed. In that situation, 100% bank guarantee cannot be invoked. There should be an exercise to find out what exactly is the amount of loss. All these things they have bypassed. At least one notice I am entitled. At least I should have got a response of my 2 letters written in 2024 and 25 in the first part, seeking extension. They should have said that we are denying or we are rejecting your application. They have not done that. Third, they have not assessed the loss. Straightway, they are trying to invoke the bank guarantee. This, in my humble submission from a government authority, is not acceptable. Although I also belong to a government authority. Assam, this AGCL is also a government-owned company. So in that view of the matter, at this stage, my humble submission would be, Lordship, that notice may be issued, give them an appropriate time to respond. And in the meantime, this operation of this 28th June 2025, that impugn notice may be kept in abeyance. If it is encased, then this whole case will become infructuous. In sum and substance, this is the overall facts. I can go to minute details also, but today is a vacation court. I would not like to take and trouble this honorable court with the nitty-gritties of other aspects.
Yes, sure. Is responding.
For respondent number 1, your lordship.
41.
1,
Yes.
Union of India lordship. For this, to lordship, Mr. R.K.D. Chaudhary has to be appearing before the court, but he is in out of station lordship. So notice we can receive the notice.
Now, a notice, definitely notice will be issued. That is no bad. But the question is that they are seeking an interim prayer for that order for not invoking the bank guarantee of 9 crores. That is the main interim prayer. So in that regard, if you want to submit anything, you can. Otherwise, from there, if it is encased or by the agent's authority, then the entire matter may be infructuous because as per them, 60-70% of work has already been done or whatever. Now, if you submit anything, then
In that case, lordship, let Mr. R.K.D. Chaudhary come, lordship. For
when
that,
when
the next date may be fixed, lordship. A date may be fixed, lordship. On that particular date, let Mr. R.K.D.
but
Chaudhary.
it is already steps have been taken, I think, na? Or
We have taken steps. Lordship may fix the matter at the last week of this month. In the till that date, this order may be stayed. On that day, Lordship may consider the interim prayer. As an ad interim, till the next returnable date, the operation of this order may be kept in abeyance. Of the impugned order 2025.
26?
206/2025. Operation of this order may be kept till abeyance till the next returnable date. I do not want to do any injustice to the other side also. In the next
Okay, then. It may be kept in abeyance because the order, the interim may not be there, but otherwise it in one sort of interim only. But till then, and matter may be fixed as per your convenience when it can be fixed, or at the end of July,
Lordship.
last week of July.
Let it come on
You want to fix
31st
it
of
here?
July, Lord.
31st of July.
31st of July.
Okay, then let it be. We'll pass the order.
Lord, deeply obliged.
The break load. You can come to my chamber Huh? We can take dictation. কেতিয়া সোমাইছা?
মনে মনে থাকা না।
আপুনি legal words বিলাকৰ লগত acquainted না? Huh?
Maybe that. My lord, the petitioner before your lordship is a government employee, my lord. And his son, my lord, minor son, my lord, posted one, my lord, controversial post in the Facebook from his mobile phone, my lord. Therefore, my lord, the FIR was lodged, my lord. Lordship, kindly have a look at the date of incident and date of FIR, my lord. Kindly, I may be allowed to refer, my lord, page 9, my lord. My lord, it is a date of alleged incident on, my lord, 9/5/2025. And, my lord, the FIR was lodged, my lord, only on, my lord, the next month, my lord, almost after 1 month, my lord. The information received, my lord, on 4/6/2025, my lord. 1 month later. Now, my lord, lordship, allegation FIR page 12, my lord. Admittedly, my lord, he is stating that, my lord, he had seen this post on, my lord, 9/5/2025. But FIR was lodged after 1 month, my lord, apprehending that, my lord, this Facebook post is, my lord, provocative, my lord.
Is that page?
Therefore, my lord, on the same day, my lord, he was arrested. Is, my lord, I-card page 15, my lord. And forwarding report, my lord, page 13, my lord. He is a government employee, my lord, and he is sufficiently matured person, my lord. His age now, my lord, 41 years, my lord. And Facebook, he is, my lord, using, my lord, since many years, my lord. It is his son, my lord, clicked, my lord, another post, my lord. He does not know even, my lord, from where this post came, my lord. And immediately he also,
What was the post? Have you annexed this?
my lord, it is, my lord, it was blaming, my lord, our honorable prime minister like that, my lord.
Oh,
His allegation, my lord, page 17, bail order, his advocate mentioned, submitted, my lord, it was recorded, my lord, page 17, my lord.
আচ্ছা।
And punishment, my lord, the part is, my lord, maximum 5 years, my lord. Up to life. It extend to up to life, 130. 5 years maximum. Life only just maximum 5 years. 183 years. And my lord, in this case,
So where is the, this one? It is annexed here? No.
That is not annexed, my lord. And my lord, here, my lord, it is not only that part, my lord. In the forwarding report, my lord, may kindly peruse page 13, my lord. With the annexure 2, my lord. My lord, that is the from the bottom, my lord, bottom 3 lines. The statements were highly provocative and intended to incite hatred, disrupt public order, and create fear among citizens, which can lead to serious public unrest, violates the law, and divert the attention from the involvement of Pakistan in terrorist activities. Now, my lord, here the section is that, my lord, 183(3), my lord. And, my lord, that part what my learned friend has submitted, my lord, when, my lord, this, my lord, that is the magistrate court, my lord, learned trial court below, my lord, when, my lord, they, my lord, reject the order, that statement is also there, my lord. That contention was made by the, my lord, the accused petitioner. It is in page 17. His minor son was having the mobile phone in his hands. So, my lord, this is something very serious, my lord. Let them, my lord,
my lord.
CD may be called for. That may be happen, my lord, because, my lord, in the social media, and nobody can, my lord, say that is the because of a post, what can happen, my lord. So, my lord, this is because of the security is related, my lord. So, my lord, may give a short date immediate after vacation,
my lord, my humble submission
my
is
lord,
that, my
CD
lord,
will be here.
he is a government employee, my lord, 41 years old, my lord. And after 1 month, my lord, FIR was lodged only on suspicion, my lord. And he is, my lord, in jail almost.
Not
my
on
lord,
suspicion, it was detected, I think.
well, he, as per his allegation, my lord, he has seen this post on that day, very, my lord. It is there, my lord, in the FIR, my lord. So, can you look page 12, my lord? he, my lord, categorically stated that on 9/5/2025, I came across a share post on Facebook, my lord. So on that day, my lord, he has seen, but FIR was lodged, my lord, after 1 month. And my lord, there is nothing happened, my lord. Only on suspicion, my lord, is the government employee, 41 years old, my lord. And my lord, he is in jail, my lord, since last, my lord, 5-6, my lord. Sufficiently, he has, my lord,
How
suffered.
many days? Since when? 5-6?
Yes, my lord. So, my lord, it is, my lord, you will not, obviously, my lord, government responsible person, my lord, he will not, it was mistake, my lord, and immediately he is deleted. So he sufficiently, my lord, suffered, my lord, and my lord, my instruction is that my lord, arrest procedure was also not maintained. My lord. On that day when my lord FIR was lodged, immediately, my lord, he was arrested. Neither, my lord, all those notice was served, my lord, even my lord, 141, my lord, notice was also not served upon him.
Okay. Call for the case, right? When it can be called for, he is in custody. Yes, Sharma?
Today, 27 days, my lord.
Yes. 23,
Well,
24,
6.
can it be?
My lord, it may be, my lord, on 16th, my lord.
16, I don't know. Some matters have already been fixed, no? I think. Okay, then we are fixing it on 16. Let us see. Okay.
16 July.
Yes. 16, 7. So, third order, good.
Diploma.
Fine. Okay.
Item 7.
Your Lordship.
Hmm.
483 regular bail application. Your Lordship, the FIR is at page number 12.
Case number 12.
12. Merit the FIR, Your Lordship.
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 20/5/2025 তাৰিখে ৰাতি 9:30 মান বজাত মোৰ ছোৱালী এক্স
electric post, my lord. That's why occurrence took place. Otherwise, it was a not so rash and negligent driving, my lord. And suddenly it had this is an act of God, my lord. So, my lord, I pray that it may be admitted, my lord. I have been allowed to remain bail, my lord. So
You
it
are
will-
already on bail.
Yes, my lord.
Should I, where is the order? Is there any order?
My lord,
Your bail is extended.
my lord, I have been asked to appear before the court within 1 month. Before that, I have come. I have been enlarged. Initially, I was on bail, my lord.
Where is the order? Order. 1 month, your extension is there. I mean, bail is there.
It order to copy the order to copy the name.
Order.
Anyway, my lord, your lordship, I have filed an IA also. Your lordship may consider my bail, my lord.
No,
I
it will
felt
be
I-
easier for us to extend your bill, but for that reason, you need the to submit that one, this your order.
My
Most
lord,
probably at the
that-
time of this.
Last session, the accused is directed to surrender before the court within 30 days. So before 30 days, I have
Thereafter-
come before the
Thereafter, is there any order?
Yes, in the
Extension?
judgment itself. Page 43.
No, to extend your, I mean, for interim, we can extend your, I mean, this earlier bill.
That's right, my lord, I have, but it was
But
not
it's
reflected.
not here.
Not
So
reflected.
in that case, you will have to
I'll go for
on
fresh
bill.
I'll do. I have filed.
I is also here.
Yes, I filed.
I think
7100, my lord.
I had asked. Yes, anything to submit?
Yes, my lord, that is criminal appeal, that is, my lord, that is disposed of on 11th of June 2025, my lord. Where, my lord, it is stated that hence this court finds no ground to interference with the decision of learned trial court. Accordingly, the judgment and order dated 13/5/2024 passed by the learned additional CGM, Baksa in PRC is yes by affirm. Then, my lord, it is in the para 22, the appellant accused is directed to surrender before the court of learned additional CGM, Baksa within 30 days. So, my lord, that is the judgment that is delivered on 11th day of June, my lord. So 30 days still is within the period of 30 days.
So what to do? Can it be hidden?
But my lord, that order is not, my lord, annexed.
Hmm.
That is the, my lord, problem.
What order is not there, brother?
The order is not there. You are allowed to remain on previous bill, that is not
Well,
there.
within 30 days, I have come before your lordship. For revision.
Otherwise, obviously.
So, if 30 days is over, then I have to surrender, my lord. So within 30 days, I have come, my lord. So kindly protect
No,
me.
we are not on that. We are allowing your
Kindly.
petition, but the question is that you have not filed the
My
order.
my
That
brother
order
has
is
filed it, probably he ought to have brought that order also, my lord.
Anyway, main case to pick up. Heard Mr. S.C. Biswas, the learned counsel for the petition, and also heard Mr. B. Sharma. No. Sorry, A. K. Bosha, the learned additional PP appearing on behalf of state respondent. Baki, this is an application, section so and so in connection with so against the in order, Yaraka Pilova. Revision petition is admitted for hearing. Issue notice to 9 state ASN. No formal notice to Likidipo. No formal notice is required to be served on state respondent number 1. However, copy may be served during the course of the day. Also for the case record of one is PRC case number 394/2021.
Yes, ma'am.
Under section 279-304A IPC from the Court of Learned Additional CGM Baksa, Mosolpur. Another one, appeal.
Appeal is by the section judge.
Appeal is also called for the case record of
Session judge.
session judge number is
Baksha.
oh sorry, session judge also called for the case record of criminal appeal number 05/2024 from the Court of Learned Session Judge Baksa. ঠিক আছে আৰু আইটোত লিখিব
Criminal appeal is 520.
Pardon?
My lord, criminal appeal number was 520 in session just case number.
No, I have written in the cause list, cause pattern.
Yes, 5/2020.
Yes.
All for the case record কৰিব আৰু আইটোত কৰি দিব হাৰ্ড মিষ্টাৰ S.A. বিশ্বাস ডিলামেড কাউন্সিল ফৰ ষ্টুডেণ্টছ কৰি দিব
I was all along on bail, but I have not misused the earlier bail order. So I will continue it till the end of the trial.
If it is an application under section 430 BNSS for granting bail to the present accused petitioner during the pendency of the criminal revision petition. Read with under section 438 BNSS for suspension of sentence and recovery of fine. Next para, it is submitted by Mr.
Well, it is there. Allow him to replace bail till I got it.
Submitted that while disposing the appeal by the learned session judge in criminal appeal number 05/2024, the petitioner dated 11/6/2025, the petitioner was asked to surrender before the learned trial court below within 30 days from the date of order, and accordingly he was allowed to remain on previous bail. Mr. Biswas accordingly submitted that the petitioner may be allowed to remain on previous bail till disposal of the connected revision petition. Next, considering this submission made by learned counsel for both sides. And so on both sides and the statement made in the petition as well as the order passed by the learned session judge Baksa, the present petitioner is hereby allowed to remain on previous bail till the disposal of the connected revision petition. And the order of sentence imposed on the present petitioner be stayed till disposal of so-and-so, be suspended till disposal of so-and-so. With the above observation, the IS stands disposed of according. Okay.
Diploma. IS disposed, but
Disposed.
diploma.
এতিয়া আমাৰ এইটো ৰেগুলাৰ কোড হয় নহয় সেইটো মই নাজানো কোনটা কি কিমান কৰিছে এইটো কোড দেখাইছে তাৰ পাঁচটা আছে উত্তৰ আঠটা আছে 16 সাতটা আছে উত্তৰ আঠটা আৰু এইটো 10টা কিমান আছে 18 বহুত আছে 18 তেইশতো আছে, তেইশত 6টা হৈ আছে, 24ত 4টা, 21তো এখন কোৱাৰ লিষ্ট হ'ব মানে আমি ফিক্স কৰাটো নহয়, অলৰেডি ফিক্স হৈ থকা মেটাৰ আছে, আমাৰ পৰা প্ৰব্লেম নহয়, আমাৰ পৰা হয় নেকি মোৰ মতে।
Number 9.
Well, please, Your Lordship. So here in this case, the accused and informant victim had jointly filed this petition for quashing of a case pending in the trial court, Lordship. Here, the petitioner number 2 lodged an FIR against the petitioner number 1, Lordship, which was registered under section 417, 315 and 493, which was subsequently charge sheeted under section 417 and 493, Lordship. And cognizance was taken on the said section, Lordship. And during the pendency of the case, there is a mutual settlement between the petition number 1 and 2.
So what is the stage of the case at present?
As appearance stage, Lordship.
Appearance stage.
Cognizance was taken as appearance stage, and they have settled the differences between them, Lordship, and executed a deed of agreement, Lordship, which is at page 27, Lordship.
Okay, then we are not in a position to pass any lengthy order because all of us are going, in fact.
So, because
Do, I think, we'll
earlier
stage it.
occasion also, Lordship, similar order may be, earlier occasion also, your Lordship has passed similar order.
No, we are not in a position to pass any lengthy order today. We are not in position, that's why. We are staying the procedure. We are staying the procedure till next date of listing. We'll fix a date. Till then, we are listing, staying your proceeding. Proceeding will be stayed, okay? Mr. These are not urgent matter. Why it has been listed in
My lord.
That should not be listed, huh? Because of urgency, it is.
Trial court, Lordship.
Urgent no matter in any fixed for this.
Maybe fixed it or reopening of the date, Lordship. Reopening of the date.
No, it is not the case of list to be listed on the vacation bench. That's what I'm saying. When your case is fixed, appearance.
It's October.
Then case is fixed
This
on
matter may
October.
be taken up on the reopening of day. Of
No. Whatever your case is fixed on when in the trial court in the month of October.
What happened, Lordship, because of pendency of the case in the trial court, Lordship, he could not apply for government job. That is why.
It's not urgent matter. Heard Mr. B. Halder, will learn counsel for the petition. And also heard Mr. K. Bushan, will learn additional PP appearing on behalf of state respondent. Document number, this is an application under section so Quashing, and to set aside the proceeding of PRC case number 317 of 2024 under section 417, 493 IPC, pending in the court of SDGMM, North Salmara, Arbitrary, full stop. It is submitted by Mr. Halder that the case has already been charge sheeted and is pending for appearance. However, during the pendency of the investigation, the parties have arrived at an amicable settlement, and for which the present petition has been filed jointly by both the accused and the victim as petition number 1 and 2 respectively. Next, considering the submission made by learning counsel for both sides, the further proceeding in PRC case number 317 in 2024, pending in the court of learned SDGMM, North Salmara, we state till next date of listing. Next, call for the scanned copy of the TCR, list the matter accordingly on. Will be after vacation.
My lord.
List accordingly immediately after vacation.
Item number 10.
Matter like any
May I please, Your Lord? My lord, in this case, my lord, NBW has been issued against the petitioner, my lord. This substitute matter, my lord, the case is pending at the stage of evidence, your lordship. Now, the petitioner is ready to cooperate the trial, your lordship. He will face the trial.
So you are shown as an absconder.
No, my lord, I have succeeded.
No, you are shown as an absconder in the charge sheet.
No, my lord, he's on court bail.
Then
My lord,
he is on court bail.
My
Then
lord.
for what? Oh, quashing.
no, my lord. NBW has been issued against him,
You defaulted.
my lord. Default in appearance, your lordship.
So you defaulted in from 16/10/2021 onwards.
My lord, in the
Then for last 4-5 years you are defaulting.
during the
Then-
course of lockdown, your lordship, the
No, lockdown to is already over now.
my lord, physical court functioning was restricted, and then he left to continue. his
Where is the
career.
last order you have annexed?
Yes, your lordship. At West 43, your lordship.
Oh, your petition was rejected.
My no, my lord. My lord, I am ready to.
Now you are on custody now.
No, my lord, he is co-accused, your lordship.
Oh, co-accused are in custody.
My lord,
Acha.
co-accused is arrested, and the petitioner before your lordship is a retired teacher, your lordship.
Very good.
My lord, only section is 498A. But he is apprehending arrest due to non-validity of section.
You are Nur Jamal. No.
No,
You are- you are-
he is Abdul Awal. my lord.
Abdul Awal. Okay, person.
So against you, there is no order there? Oh, it's submitted.
Page 43, my lord, of the petition, my lord, last part from the bottom, my lord.
Hmm.
Co-accused Abdul Awal is absent, and BWA issued against the accused has not returned. Issue phrase.
No. Abdul Awal.
Abdul Awal, your lordship.
43 page number where? Oh,
Last-
this handwritten portion.
My
Part, my lord, 21/6/2020.
And since when your NBW? Pardon?
It is in page 41, my lord, 29/3/2025 order, my lord.
No, from 21 onwards, the
I-
NBW
I-
was issued.
NBW issued, my lord.
PNA is also issued, na?
PNA is
not against
issued
this
against,
person.
my lord, that is
Court.
Nur Jamal Haq, who was later, my lord, arrested, my lord.
Acha.
PNA issued, my lord, that is. But NBW, my lord, for a long time, my lord, this. Why, my lord, PNA not issued, I don't know.
So where the first order when your NBW was issued?
That is, my lord, 16/10/21, your lordship. Page 33, your lordship. Page 33. On the day of resuming the court functioning, my lord, after COVID.
Yes, from Bushani.
Here, my lord, there is. NBW is there for a long time, my lord, there is no later part, but he is stating that he will go for. He will appear before the court. PNA not issued, my lord, but NBW for a long time.
Some protection.
Heard Mr. A. Rahman, the learned counsel for the petition, and also heard Mr. K. Bushra, the learned additional PP appearing on behalf of state respondent. This is an application on section so and so in connection with so and so. Post op. It is next by, it is submitted by Mr. Rahman, the present accused petitioner was earlier granted bail, but during the COVID period, he could not appear before the learned trial court below, and that apart, there was restriction in the court functioning. After the reopening day, immediately, the NBW was issued against the present petitioner on 16/10/2021, 16/10/2021, 21 against the present petitioner. He further submitted that the accused petitioner was not aware about the issuance of NBW against him, and he was also not provided with any, and he was also not could not contact with his engaged counsel, and for which he could not appear before the learned trial court below. However, he is ready and willing to contest the case by appearing before the learned trial court below on each and every date to be fixed by the court. Mr. Rahman further submitted that as the NBW has already been issued against the present petitioner, he may be arrested in connection with this case, and hence the filed the instant petition. It is prayed for quashing of the order for issuance of NBWA against him, dated 16/10/2021, and all the subsequent dates orders. Next paragraph, Mr. Bushra, the learned additional PP, submitted in this regard that since long the NBW was issued against the present petitioner, and he is not appearing before the learned trial court below and cooperating in the case, and not the cooperating the learned trial court below. However, he submitted that direction may be given to the present petitioner to appear before the learned trial court below with an appropriate application for bail. Next paragraph, considering the entire submission made by learned counsel for both sides, and also considering the order passed against the present petitioner, which has already been annexed along with the petition, this court find it proper to the petitioner is hereby directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law within 15 days from the date of order. Until then, the execution of NBWA issued against the present petitioner be suspended. With the above observation, the given petition stands disposed.
Obliged, much obliged.
Item 11.
May I please, my ladyship?
Yes.
My ladyship, item 11 is an urgent matter for this reason. If my ladyship would have page 54, this is a notification that we have impugned in the present writ petition. Page 54, annexure 1. And pursuant to this, ladyship, the verification process has started day before yesterday. From Friday, the verification process has started. This is the impugned notification. If I could just give a brief background and not more than 1 minute, ladyship, I understand it's a vacation court, I won't take much time. Just 1 minute I'll take to give the brief background. My ladyship, this matter pertains to assistant teachers in the government of Assam primary schools. There's an advertisement of December 23. The advertisement is annexed in the present writ petition. We, my ladyship, the petitioners before my ladyship, are NIOS, National Institute of Open Schooling, Diploma in Elementary Education, DLED in short, NIOS DLED holders. There was some litigation that happened between state of Uttarakhand, etc., different states, my ladyship, which went up till the Honorable Supreme Court. The Honorable Supreme Court initially said that the in-service, because the qualification or the eligibility of all of us was in question. Finally, the Honorable Supreme Court on 10th December 2024, says that we, the petitioners, are eligible to participate in the recruitment process for teachers from class 1 to 8. That is what the Honorable Supreme Court says. And that order, my lord, my ladyship, is the basis of this entire writ petition. My ladyship would first see that order of the Honorable Supreme Court where State of Assam was a party. The order, my ladyship, would find at page 567, annexure P4. That is the basis of the present writ petition and how the state is misinterpreting and misunderstanding the order of Honorable Supreme Court. 567, annexure 4. State of Assam is a party in this order. My ladyship would see on top, the number is given as die number 4961 of 2024. at 567. The relevant, my leadership, would kindly come to 568. The very next page. The next page I am reading para number 2, my leadership. We are falling in this category. We have already clarified that in the judgment under review that one-time scheme was provided solely to safeguard the interests of those teachers who were employed as on 10th August 2017. We are therefore not inclined to entertain the present review petitions as well as miscellaneous applications. Now, para 3 is very, very important. However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons, which is me, my leadership, who were in employment as on 10th August 17 and who have completed the diploma course of 18 months would be treated as a valid diploma holders for the purpose of applying in other institution or for promotional avenues. Needless to say, the clarification will be effected from the date of pronouncement of the judgment under review, thereby meaning leadership, this was given a retrospective effect. So this is a clarification that came by the Honorable Supreme Court that if there are these two conditions are met, which is you should be in service as on 10th August 17, plus the second that you should have completed the NIOS DLED course within the specified time, you will be considered as a valid diploma holder. On the basis of this, my leadership, this Honorable Court allowed my writ petition. There were multiple writ petitions filed before this Honorable Court. The order, the relevant order starts at 563. 563 is the order of this Honorable Court, which allowed my writ petition on the basis of the Honorable Supreme Court's order. My leadership would see 563, Annexure 3. This is a writ petition filed by me, by the same very petitioners, and I had the opportunity to assist my lords at that time. My leadership would see the relevant part at 565. At 565, by filing these writ petitions, the petitioners who are 18 months, we are the ones, leadership. The diploma holder in elementary education from NIOS challenges the notice dated so-and-so issued by so-and-so, whereby it is informed that all for the purpose of advertisement, the same very advertisement we are questioning today, the 18 months diploma in elementary education acquired from so-and-so will no longer be a valid qualification. We challenge that. Then the findings are given. Then please see 566. Straight away, my leadership could come to 566, the second paragraph. Having considered the stand of NCT at 566, NCT, my leadership, is the National Council for Teachers Education. They are the rightful authority by which they prescribe the requirements as to what will be the eligibility for us, the teachers. Having considered the stand of the NCT, respondent number 4 herein, the court on so-and-so had directed Learned Standing Council for School Education Assam, so-and-so, to obtain instructions and to clarify the stand of the state government with regard to the recognition of 18 months diploma in elementary education. Mr. So-and-so Learned Standing Council submits that in view of the clarificatory order by the Honorable Supreme Court, in case of Vishwanath, although the notice dated so-and-so was issued so-and-so before the order of the Honorable Supreme Court, by now, the 18 months diploma in elementary education acquired by the petitioners would be recognized. Very, very important. That is the state stand. Having considered the learned counsel for the parties, and we are of the view that the order dated so-and-so passed by the Honorable Supreme Court regarding the 18 months diploma in elementary education obtained from the National Institute of Open Schooling, and consequent to which NCT has forwarded order dated so-and-so to all the secretaries and commissioners of so-and-so. I am of the considered view that no issue remains to be adjudicated, as the same has been settled by the Honorable Supreme Court and so-and-so. It is made clear in view of the order dated so-and-so, the impugned notice dated so-and-so shall not have any effect. So therefore, the writ petition was allowed and we were considered to be eligible. Thereafter, what happens, ladyship? The impugned notification is released at page 54. So once they say we will consider you, then they come out with this impugned notification. Which, my lady,
page
54, I'm sorry, 54, 54. I'm sorry, my ladyship has to turn that voluminous pages. It's just that we have put all the proofs together so that everything is at one place. Kindly see page 54.
Yes.
Please see the opening line, ladyship. It is dated 17th June 2025. When counseling starts, the document verification is started from 27 June. I'm reading the opening lines. In view of the judgment of Honorable Supreme Court passed on so-and-so in review petition so-and-so, in case of Vishwanath and others versus State of Uttarakhand, the applicants who have successfully submitted their online application with 18 months DLED from NIOS against the advertisement dated so-and-so are hereby asked to attend the second phase of physical document verification in due course of time when notified in so-and-so, so-and-so, so-and-so to as in-service teacher. The problematic part is list of testimonial and documents. This is the problematic part in this particular notification. Now, what are they asking in my humble submission? Beyond the scope of Honorable Supreme Court's order is 1 onwards. Kindly see 1, papers related to proof of in-service as on 10th August 17. First, they are asking for appointment letter and accepted joining report of the applicant. Second, they are asking of minutes of social matching committee of the school in respect of the appointment of the applicant concerned. Third, they are asking for attendance register. Fourth, they are asking for certificate issued by school authority. Fifth, they are asking for salary statements. Sixth, they are asking for UDIS records. I'm glad they did not ask me for a selfie sitting in the school that I am teaching. So they asked me 6 documents, which is nowhere mentioned in the Honorable Supreme Court's order. And the document verification has started last Friday. And they say, my ladyship, that all these 6 documents are mandatory. The question that I put to myself is, where does the state get the power to ask for these 6 documents when the Honorable Supreme Court has not said anything on this? However, my ladyship, what is most important, because I had the opportunity of assisting the Honorable Supreme Court in these matters, what was there before the Honorable Supreme Court is very important. Hence, I will request my colleague to just tender a compilation of documents in which this order was passed. Just have a look at those documents. It is a part of the record. What was there before the Honorable Supreme Court was only 1 document, that on this basis you have to prove that you are in service. Over and above that, nothing was required. So kindly have that 1 document compilation, if my ladyship would see. It is the heading of the page, the first cover page says in die number 4961. This is as it is from the Honorable Supreme Court's compilation. In this, my ladyship would just see 1 letter, and this was argued by us before the Honorable Supreme Court to get this 1012 order. Kindly come to page 47. Page 47 may be seen, my ladyship. This is a letter dated 3rd August 2017. My ladyship would see that the second paragraph of page 47, this is a letter issued by MHRD, Ministry of Human Resource Development, School Education and Literacy, Government of India. They are the ones who had introduced this course, which was a one-time course, and this is the first letter by which these guidelines are being laid down for this course, which the Honorable Supreme Court considered. Then please see at 47, the second paragraph, which says action to be taken by states and UTs. May I read, ladyship? The first action is states and UTs. So it is the state of Assam will be responsible for ensuring that all in-service untrained teachers in the state and UTs acquire the minimum qualification required under the RTE Act within the proposed extended period till 31st March 19. My ladyship just noted that this is dated 3rd August 17, prior to the course. Then, very, very important, please come to 48. Please come to the very next page. See who has the responsibility of checking whether I was in service or not. Please see Roman 7. Very, very important. Roman 7. All states should prepare a database of such teachers in their state. Who are these such teachers? These are teachers as mentioned above in service. The responsibility to give this data was on the state, not on me. Then please see the next one. 9. Roman 9. State coordinator will enter. It's again the state's responsibility. I am not the one who can just go and apply. The state has to first recommend my name. State coordinator will enter the entire database of untrained in-service teachers in government and private schools on the portal especially prepared by NIOS for this purpose. This portal will also be utilized by the to monitor the process of the training in each state. So it is the state who had to verify in 2017 whether I was in service or not. Now, the most important part of my argument, my ladyship, please see Roman 10. For teachers in private schools, a certificate from the principal would be taken to ensure that the teacher is serving in the school. These certificates will be collected by the state/union territory. And then please see the next one. Once the above information is provided to the state coordinator, then NIOS will provide the following to individual principal. So it is everything between the state and the school. I had nothing to do if I was in service or not. And then to add on to this point, please see page 49 also. 49, there's a timeline given in the bottom. Please see the fourth timeline, which is 20th August 17, which says states and UTs will submit complete database of all in-service untrained teachers in government and private schools to NIOS. I would just pause here for 10 seconds, ladyship. Unless my name was there in the list given by the state to this institute, I couldn't have taken this course. The responsibility to identify me and to give my name was on the state. So therefore, today saying that please give me these 10 documents to show that you are in service is redundant. There is absolutely non-application of mine when these 10 documents are being asked from me, when the responsibility on the state throughout was to give my name, that whether I was in service or not. Plus, my ladyship, just adding on to this, even as per the document which was there before the Honorable Supreme Court, what is there? The only document is principal's certificate, which I have annexed. Please see one example. I put it in the writ petition. Please see one example. Page 59 is one of the examples. This certificate is available for every petitioner. Please see page 59. I have put for every petitioner. I am showing you just one example. Please see 59. This is Binodini Public Academy. Please see teaching experience certificate. This is to certify that because this son of so-and-so have qualification graduate, he has 9 years of experience. He has joined the school on 13 Jan 16, is still serving the school to the best of his duties. So this certificate is available for every petitioner, page 59 onwards. Continues for every petitioner. At page 68 is the other petitioner. So ultimately, my ladyship, what I am trying to reach at is that once the Honorable Supreme Court has given a finding on a particular aspect, this Honorable Court has followed it. At least 9 different states have followed it. Punjab has followed it. KBS has followed it. Multiple states have followed it. West Bengal has followed it. Everywhere, the only document to show that I was in service is this experience certificate. There is nothing more required. Plus, very, very important, there were previous recruitments done by the same very state. It is not as if we are being recruited for the first time. Please see the document that they asked us in the previous recruitments. Please see 638 for a minute. They never asked for all these 7-8 documents. At 638 is the notice of a previous recruitment for us. At 638. I put the document verification notice at 638. This is dated 15th March 23. I'm sorry. (638). 15th March 23. My ladyship would see para 1. The candidates must attend the physical document verification along with all relevant original documents, copy of online application, self-attested photocopy set of all documents. There is nothing that I need to show for in service. The advertisement is just 1 page prior, where none of these documents are mentioned. And not just that, ladyship, they have similarly placed ODL candidates who have done a course from the state SCERT also. None of these documents are being asked for. So why should there be a partiality qua me is the primary argument that I am trying to canvass. In this backdrop, my ladyship would please come back to the impugn notification. The impugn notification, I'm sorry. And for other states, ladyship, I can say with responsibility because at least 8 high courts, KBS, I have appeared myself. I can say that with responsibility. None of them are insisting for anything apart from this experience certificate, which the Honorable Supreme Court has said. So therefore, one state in one recruitment, which they have not done previously, how can they insist for 9 of these documents, which we were never made aware of? The reason, and please see 54 with me for the last time. before I proceed to make my prayer. 54, my ladyship, what is the problem? One, there is no power. Under which provision of law at 54 is the state asking for these documents? Which provision of law? In fact, BTR has also implemented it, ladyship. Honorable Supreme Court 5 days back has passed an order in BTR's case where they have to issue appointment orders. Please see 54. Now they say appointment letter and accepted joining report of the applicant. I am giving the experience certificate which was required as per the original NCT notification. Minutes of social management committee of the school in respect of the appointment. How can I have it, my ladyship? I am an applicant who had taught in a school 8 years back. Where do I get this from? What is the power of asking for this document? Then see photograph of attendance register. Unfortunately, ladyship, post 2019, post COVID, most of these schools have closed. The cutoff date as per Honorable Supreme Court's order is 10th August 17. Was I teaching on 10th August 17 is the thing to be seen. I have produced experience certificate for everyone. Now, where do I get these attendance registers from? If the school has closed 5 years, 6 years back. Then please see the next one. A certificate issued by the school authority, which I have already produced. That is the only thing that I have. Salary statement. Most of these schools have paid salary to me in cash. Where do I get all these things from? My ladyship would understand that, would appreciate the fact that we are not the principal of the school. We are some schools teachers teaching in the primary school at some meager amount. And then the UDIS records. I must also say these UDIS records are not even mandatory even today. Every school to have, like we all of us have Aadhaar cards. Similarly, schools will have these UDIS records. The state has not mandated these UDIS records even till today. They'll mandate it from the next very year.
Okay.
So therefore, my ladyship, my interim prayer is this. Because there are two notifications which say that counseling, verification has started from 27th onwards. The second is starting from tomorrow. We'll give that proof. I'll request my colleague to just hand over that proof where it says that Friday the first counseling has started and the second one is starting from tomorrow. Either my ladyship would consider staying them. Because unless they follow the circle or the square covered by the Honorable Supreme Court, it cannot go. Or my ladyship would say that they should not insist for anything over and above the experience certificate subject to outcome of the writ petition. I have absolutely no problem. Because once I go, all of these documents are not, they do not have the power to ask for it. I don't have these documents because the Honorable Supreme Court never said. The state gave all these in-service documents or details to the NIOS. Let it be stated at least these provisions where these other than the experience certificate, if anything is asked for, let it be stayed till the next date of hearing. Or the process may be kept in abeyance. The problem is this, that if an interim order today is not passed, the document verification last will conclude by 8th of July. That is the last document verification to be completed, and there are about 4,000 students in the candidates in the list. About 3,572 candidates are in the list. If the document verification is complete, then there'll be a new cause of action that will come in. And it is not as if I filed today. I filed it at least 7 days ago. But they released the document verification list 2 days ago. So therefore, my ladyship, my humble prayer, and I am so grateful for a patient hearing. My humble prayer is twofold. One, either kindly stay this process so that this issue of what can they ask for, or I'm so grateful, ladyship.
Lawsuits, first of all, this petition was filed on the basis of an apprehension lawsuit. On apprehension date, their candidacy will be rejected by the impugn order. That impugn order, what is the impugn order lawsuit? Page 54. And before the lawsuit may kindly turn to the annexer, they have annex as page 623 lawsuit, which is a judgment by the Honorable Supreme Court lawsuits. 623 lawsuit may kindly turn to 623 para 40 lawsuit clause 5, whereby they were allowed by the Honorable Supreme Court lawsuits. May I read this? We clarified the source of the teachers who were page 623 lawsuit. 623 para 40 clause 5 lawsuits. This is judgment passed by the Honorable Supreme Court lawsuits, whereby it is stated that we clarified the source of the teachers who were in employment as on 10th of August 2017 and who completed 18 months of DLED ODL program through NIS before 1/4/2019 shall be considered as valid diploma holders for the purpose of applying for the institution. And accordingly, we have applied lawsuits. We have allowed them to apply lawsuits. They have applied. And next, clause 6 lawsuit, we direct the respondent authorities to consider the candidates of such appellants who were in service on 10th August 2017 and that who on verification lawsuit. There's a question of verification is their lawsuit. So why they are afraid of verification?
No, I'm sorry, they are
And the
misreading.
verification is continuing till 8 lawsuit, 8 of this lawsuit, August, no, July. And thereafter lawsuit, there also lawsuit, it will not complete then. Then if there's any absentee during this period, 27 to 8, then we'll again call them. There will be 4 sessions will be held thereafter after 8 lawsuit. Let them appear, let them file, submit their lawsuit documents, whatever they ask for, and this notification doesn't contemplate that they will be rejected lawsuit. Where is the they only on application they have filed this petition lawsuit? Whether the lawsuit will allow this petition? There's no question of issuing any interim at this stage. Let them appear and submit all the documents lawsuit. Why they are afraid of?
No, as per their intention, they don't have those documents.
Whatever documents they have, let them.
That can be, that
whether
can.
we have taken any action against them, whether we have rejected their candidates lawsuit. No.
Till now, no.
Till now, then where is the question of filing this petition on application lawsuit? And verification process is still continuing, and it will be continued thereafter also. And during this period, if there was anyone absent from this verification process, they will be again called for lawsuit. There will be another 4 round of session to be going after 8 of July. So at this stage, no lawsuit issue notice, let it fix immediately after vacation. I will take the instruction from the authority lawsuit.
Learned counsel is trying to mislead. Kindly see what he was reading.
No question of misleading.
One second, please. I didn't utter a word when he was speaking. Please see the first page of the paragraph that he was relying upon. Please see 597. The judgment that he is reading is of West Bengal. It is not of this court, or it is not concerning Assam in any manner. I appeared in this matter, so I can very categorically say, please see the first page of the paragraph that he was reading. Please see 597. It does not concern Assam. 597, if my ladyship would see the paragraph that he was reading, it is Quashing Das versus State of West Bengal. 597. And the issue, one second, sir, if you don't mind. The issue in this matter, my ladyship, was that the allegation by the state was that there was no TET. The people who had applied had not given TET. That is recorded in the judgment. If you will please see this judgment, this is not the main judgment of 4961. In fact, if he wants to see, kindly see a judgment. Please see 597 for a minute. This is concerning only West Bengal. And this is an SLP against an order of the High Court. In fact, a similar judgment has been passed by the Honorable Supreme Court at page 585 for Uttarakhand, where they have not spoken about verification. Please see 585. What is my learned friend referring to? Please see 585. I have argued this judgment very well before the Honorable Supreme Court. Please see 585.
Now, ultimately, this
sir, 1 second. Please let me complete, if you don't mind, sir. 585, my ladyship, is a judgment pertaining to Uttarakhand. And see the operative part at the operative part, my ladyship would see, comes at 593. There is no question of verification. Please see the operative part. 593, para 21 is important. Indisputably, the other institutions would also include the schools run by the state government. At 593, para 21, I am reading. And then see 23, very, very important. We therefore direct the state government to consider the claim of the applicants in accordance with clarification done so. And if the applicants are found to be eligible, to appoint them in accordance with law. Now, it is my case that as per the advertisement, all of us are eligible. We are meeting the eligibility criteria. It is not my apprehension that they will reject me. I am questioning the source of power. My ladyship, if the impugned notification is seen, it does not even disclose the source of power. How can a government release a notification without justifying that what power does it have? Please see 54. Not even a whisper. The only thing that they are saying is we are relying upon Supreme Court judgment. The Supreme Court never said that you can ask for these 8 documents. In fact, I showed those documents before the Honorable Supreme Court. It was the state's duty to tell that who is in service and who is not in service. Today, going the clock backwards after 8 years, what purpose would it be met? So therefore, ladyship, it is not right to say that it is my apprehension. I am not apprehending. I am challenging the very source of this notification. And that I can only do if I... So therefore, my ladyship, please kindly consider, because ultimately it's 3,500 people. Today, if it is not stayed, there'll be 3,500 more petitions coming in, because ultimately, if you please see the opening lines of 54, it does not talk about anything else, only the Honorable Supreme Court's order. Honorable Supreme Court order does not say so. It only says you are.
On page 37, paragraph 13.16, it is the apprehension. The petitioner reasonably apprehended their condition may be arbitrarily rejected.
Well, that is one of the grounds. I'm sorry. And
Why they
there are at least 8 more grounds.
Let me appear and verify whatever documents they have lost.
There are at least 8 more grounds.
Action, then they can come to this honorable.
No, I'm sorry. I'm challenging the notification. Please see my prayers. Please see my prayers.
Pleaded they on apprehension that they'll be arbitrarily rejected, and they've approached this honorable court.
Please see my prayers at page 48. It is not just apprehension. I'm sorry.
Outside instruction in this case.
My ladyship, the writ petition cannot be read in bifurcation. I'm sorry. Please see my prayers. My prayer is very clear that except experience certificate, 1 second, sir.
Anything that we will take any action, only ask that.
My ladyship may record their statement and they will not take any action. They will do the document verification and not take any action. I'm happy with that.
They have stated that they will apprehend.
Please see my reliefs. It cannot be that both of us keep arguing at the same time. Please, sir, you can conclude, then I will put my word. Please.
And this is not a case to be filed in the vacation court also. No,
I'm sorry, my ladyship. I'm sorry. If I'm challenging a notification of 17 June by which the verification has to be conducted from 27 June and 1st
They filed this case on 27th. They have listed it today.
I have filed it on 25th. We have mentioned twice, my ladyship. The registrar said, please move it in the vacation court. My concerned colleague is there. Twice they have tried to mention. So, my ladyship, one of these prayers is very, very important. I will urge my ladyship to consider one, either staying it, or the document verification may happen without the experience certificate. Third, the most reasonable I am trying to say, let the results not be declared. Let the results of document verification not be declared, because then, 1 second, sir, what is this apprehension, please? Let the results not be declared so that the equities can be balanced. What would happen if the results are not declared till the next date of hearing? At least this issue could be decided.
The result is so far most probably till 8th of July, the verification will be there, and then only as Master Authority has submitted that 4 or 5 rounds of the reassessment.
My ladyship, there is nothing on
will
record.
be there also.
There's nothing on record.
That's why it's not a question of result is not so thing.
No, we are not.
Anyway,
unfortunately, there is nothing on record. There's nothing on record.
Yes. Okay, I'll pass the order.
Yes.
My ladyship may at least consider. My ladyship may kindly consider there is nothing on record to say that after 8 July it will continue. There is nothing on record, not even a single paper. So therefore, ladyship, if nothing is done at this stage, the entire petition will become infructuous, because I am challenging the basis on which this notification has been issued in clear violation of the Honorable Supreme Court's order. The specific document that I showed, my ladyship, I'm sorry.
There's nothing on record. There's
1 second, sir. 1 second,
please.
Have some courtesy, please, sir, if you don't mind, sir. Please. Ladyship, those documents that I showed clearly say that the only document is experience certificate. I understand my ladyship.
Yes, I have understood your submission.
Yes. So only one of these 3 interim prayers may be considered, or else this writ petition will be infructuous. And I'm not saying make it an interim, make it given add interim order till the next day. Please have it at any date as convenient to the learned government council. But until the next date, this writ petition should not become infructuous. Let them not take any action on these document verification. Let them not publish the result of the document verification. At least that much can be done. I'm being fair to the court. I mean, I'm being most fair to the court. They don't stay.
Pardon? What is submitted?
The impugn notification doesn't reflect that we'll take any. We have only asked them to submit the documents only.
Ladyship, they can take 24 hours.
Arbitrarily. On application, what are lost?
Within 24 hours. Within 24 hours, they will publish the result. They have done it in past. And I have come well in time. If this interim order doesn't come, the problem is it will become infructuous. Please see.
Nothing will happen. Okay.
My ladyship may record his statement, then nothing will happen. I will be very happy with that.
Oh no, that statement I'll definitely record. I will record that statement. I have submitted that.
That nothing.
5 rounds of
recorded time, I'll be more than obliged. That till next date, whatever date, nothing will happen.
Okay.
And also, the Supreme Court has directed the verification of the page 624.
That is most probably as he submitted, it is the connection of
West Bengal only.
Bengal.
And they have relied on a Uttarakhand case lawsuit.
Uttarakhand and West Bengal.
And now I am relying on
State of West Bengal.
Yes,
West Bengal, the issue is different. If my ladyship would see
by the Supreme Court lawsuit, is binding on all.
No, no, my learned friend did not have the
Anyway,
opportunity to assist the Honorable Supreme Court in that
Last of
matter,
July,
but I
Lordship.
had.
On
I
20th of
had the
July.
opportunity. The issue there in the judgment is written. It is written that the apprehension of the state is that most of these eligible teachers would have not qualified tech, and hence the verification comes into picture. It is not the apprehension here that we have not qualified tech. So they are mixing two issues. I can say it with responsibility because I argued that matter.
This will go only under.
And that is recorded in the
on the final hearing.
Okay.
I'm sorry.
20th of July, Lordship.
You need on 28. Okay.
My ladyship, 28th may be slightly difficult. Can it be a day thereafter?
Thereafter?
Yes. Can it be 30th if possible?
30th.
30?
Yes.
Okay, 30.
And but my ladyship may consider on the interim prayer and
Pass the order.
Lordship. That will.
I'm so grateful.
I heavily objected regarding it.
Well, let him object, but at least his statement may be taken into account because it will become infructuous, my ladyship, and we are 3,500.
Okay.
And I must also mention 8 states have implemented without asking for anything else apart from the experience certificate.
That you have already submitted. Yes.
Yes, KVS is one of the most important.
West Bengal has seeking similar kind of lordship documents, very for verification. That will produce on that day.
Okay.
I'm so grateful, ladyship. I'm so grateful. Deeply grateful.
May it please your lordship. Lordship, the petitioners are currently discharging their duties as President and Secretary of Dhemaji District Tiwa Christi Bhavan. Lordship, they were aggrieved by the impure notification. Lordship, this is response page number 40.
Yes, there was a civil suit was also pending.
Yes, Lordship, it was disposed and rejected by the civil.
No. I have gone through the
Yes.
civil suit was there, which was disposed of,
Yes.
and subsequently one eviction
Yes,
notice
Lordship,
was
but
also
no action has
issued
been
today.
taken so far. Yes. The land was allotted us to beg in 2022, Lordship, but still.
Yes, you're saying that no eviction order has been taken place till now,
Yes.
or that has
The
not been
market
implemented.
stands, Lordship.
Better that can be, yes. Yes.
They're sending that it will be start giving a post of the in the morning also I am telling I have no confidence.
You have not served the copies.
My sincere apologies, Lordship. There may have been a mistake during my clerical work. I'll make your Lordship the copies that served to me.
No, without copy, how they will submit today? And that apart, it is the why it has been fixed in the vacation code because I don't find such.
The notice is not part of 16(6), my lord.
Yes.
Now, my lord, they have 7.
Yes, Lordship.
How many days, my lord, do you have part of 14?
Not even 15 days, Lordship.
Notice for eviction by the municipal.
Yes, Lordship.
That my lord, they are.
The matter is not only just a eviction, Lordship.
They are running the market there. That's why they are asking them to get that place.
But Lordship, how can they run a market if the land belongs to us, Lordship?
Sit on the regular.
Because
No. Question is
Yes,
that
and
the
in the
land
meantime-
was
the land was allotted to us, Lordship.
allotted to them
It was a
as per
government
the
land.
order, and then subsequently it was being used by respondent number 4 or whatever, the other respondents. And subsequently then after the civil order, they have passed one notification for eviction by the municipal board. Now his contention is that notification or the eviction process is not yet completed or not yet initiated rather. That is the main issue, I think. But I don't think it's so urgent.
If it is their land lordship, then how one can enter and that means do their business lordship?
No, it was unauthorized.
It was unauthorized land, Lordship. It was government land earning.
You can enter unauthorized in this case. So then if you have not received any copies till now, we just simply issue notice at that time. During this course of the day, or will be after.
Immediately after the vacation lordship.
Because only 14-15 days has been elapsed after the issuance of
Yes,
the
Lord.
eviction notice.
Lordship, notice was issued on 16, but the date was given till 21st.
Date was given.
Yes, for them to evict a certain said plot of land, but still the market it stands, even the bus stop and rickshaw stand it stands.
That's what I'm saying. The notice was of 14-15 or eviction notice was they were asked to evict by 21st of this June.
Yes, sir.
But till that, now 14, 15 days have been gone, I think. So at present we are issuing notice only.
Yes, Lordship.
And you
Release.
buy a copy, you may furnish a
Yes.
copy to the other side. You are Mr.
NJ Demarcation.
Eh?
NJ Demarcation.
Acha. Heard Mr. NJ Demari, the learned. We are on 12th. We are on 12th. NJ Demari, the learned counsel for the petitioner. And also heard. Yes, you are appearing for
I'm for appearing for 2 and 3, Lordship, M. Bhattacharjee.
M. Bhattacharjee, the learned senior government advocate. Your additional senior government advocate for respondent number 1. Sorry, 2 and 3.
He's for 1, Lordship.
You're for 1.
SC Revenue.
You are agent?
SC Revenue.
SC revenue. So revenue for 1.
For 4 and 5 notice need to be.
Full stop. This is an application, section so and so in connection under article so and so in connection with so and so. For non-implementation of the eviction notice dated 16/6/2025 issued by the respondent number 5 to the respondent number 4 to vacate the said plot of land. Next para. Issue notice on the respondents. However, no true registered AD and as usual process, but no formal notice is required to be served on respondent number 1, 2, 3. 1, 2, 3. 1, 2, and 3. Further, it is submitted that it is further the copy of the petition, the petitioner is hereby directed to serve the copy of the petition within course of the day to neighboring the course of. Do you have the copy with you now?
Yes.
During the course of the day, and list the matter accordingly immediately after vacation. Immediately after vacation, as on a date to be fixed by the registry. You serve the copy, then we can try to pass it out.
Extra copies also, if Lordship is issuing notice, Lordship. In the meantime, we'll be.
Or serve the copies. Extra copies order I have already passed.
Lordship.
Highly obliged.
Deeply obliged.
13.
Made peace, Lordship. When the petitioner before Lordship, my lord, had participated in my lord for allotment of a petrol pump, my lord. Here, my lord, the
Inspector?
petrol pump, my lord.
Acha, Petrol.
Here, my lord, the IOCL authority has published an advertisement, my lord, for allotment of petrol pump, my lord, in between, my lord, Bhavanipur Police Point
Area.
and Howli Police Point, in between, my lord, on the left side of the National Highway 27, my lord. Accordingly, my lord, the petitioner has submitted his application, my lord. Subsequently, my lord, he was selected, my lord. After selection, my lord, he was asked for submission necessary particulars like my lord, land documents, etc., my lord. And after submitting of the land document, my lord, the IOCL authority, my lord, suddenly, my lord, had cancelled the selection of the petitioner, my lord, saying that other co-partner had not, my lord, submitted the NOC, my lord. Here, my lord, the lease agreement, my lord, was as per their requirement, my lord. Moreover, my lord, your lordship goes through the clause 4, my lord, page, my lord, page 23, kindly, my lord. Page 23, my lord. May I read, my lord? Here, my lord, clause 6, my lord, land, applicable to all the categories under the heading of, my lord. Kindly see, my lord. The applicants would be classified into 3 groups of as mentioned below based on the land offered or land not offered by them in the application form. Group 1. Applicants having suitable piece of land in the advertised location area either by ownership / long-term lease for a period of minimum 19 years 11 months or as advertised by the OMC, my lord. Kindly come to my lord. Yes, there is a paragraph, my lord. Below, my lord, in case land offered by all the applicants under group 1 or group 2, it is
is found not suitable or not meeting requirements, then these applicants under group 1 and group 2, along with applicants under group 3 who did not offer land along with application, would be advised by the OMCs to provide suitable land in the advertised location states within a period of 90 days. Here, my lord, please come to my lord. What documents, my lord, they have got, my lord? Can you come to page 109, my lord?
Page
119, my lord. It is a part of annex. Annex starts from 118, my lord, annex 7, my lord. These are the documents, my lord. Yeah, my lord.
None, all the co-partners were not,
No, my lord. Only there are two brothers, my lord. The land was against the name of two brothers, my lord. One of the brothers, my lord. In fact, my lord, circle officers are also certified that a land measuring one katha, 1 bigha so and so pertains to the lessor, my lord. That was submitted before the ICL authority. And my lord, moreover, my lord, the ICL authority, my lord, what they have done, my lord, in fact, my lord, as per their own brochure, my lord, that terms of the brochure, my lord, tender documents, my lord, they should have given at least 90 days time, my lord. If they are not satisfied with my proposal, my lord, of land, I could have make alternate arrangement, my lord. But instead of giving that stipulated 90 days, my lord, they had allotted to some other man. And my lord, on NOC, my lord, when a lease is applied, my lord, definitely, my lord, NOC was obtained from the Deputy Commissioner Office, my lord. And NOC is not like that, my lord. It is NOC is there, is issued, my lord, after verifying, my lord, on the field report, on the basis of Lakmondal report also, my lord. When all the requirements are fulfilled, my lord, suddenly, my lord, they have come, no, we are not, that land is not suitable because co-partner has not issued NOC, my lord. There is no question of NOC, my lord, because already lease, it has already been executed, it has registered sale lease, my lord, under by the office of the sub-register. Now they are saying, my lord, even if, my lord, if they are even if not satisfied with that proposal, my lord, they could have asked me, because there is 90 days time, my lord, they could have asked me, within 90 days, you have to arrange alternate land, my lord. Definitely, I could have arranged alternative land, my lord. Instead of doing so, my lord, they have allotted to some other person, my lord. Now the date is fixed on 7th of this month, my lord. Next month, my lord, 7th July, my lord. It's totally arbitrary, my lord. Can come to page 135, my lord, page annex 14, my lord. 135, my lord. Yeah, my lord, they have already, my lord, initiated that the lottery process, my lord. Here, my lord, it was written to one Hairul Islam, my lord. Here, we are pleased to inform you that you have qualified for draw of lots for selection of RO dealership. You are requested to present personally along with photo identity card issued by any government department on 7th July. Again, the same, my lord, the petrol pump, my lord. My lord, they have violated their own guideline, my lord, their own tender condition, my lord.
yes.
My lord. My lord, his application was selected provisionally, my lord.
Provisionally.
Yes, my lord.
Hmm.
And my lord, my peruse. Just a second. And it was clearly stated, my lord, that only after verification, like if everything is sorted in the verification, then he will be allotted. So, my lord, my peruse, page 1626.
120, yes, my lord.
126.
Yes, my lord.
This
Whereby,
is
my lord,
impugn communication, my lord. My lord, if I may read point number 2.
126.
Yes, my lord. Point 2, my lord.
Hmm.
Please also refer to a letter dated 27 Feb 2024 and letter dated wherein you were advised to be present personally for field verification of credentials by officers. This is to inform you that during the field verification of credentials, you failed to produce the original documents. So what has happened, my lord? On that day, the original documents was not aligned with the documents we have submitted in the portal. So, and then for verification by the officers, the documents produced, you were at the variance with the documents submitted, information given to in the application. As per attached, Jamapandi of land, the offered land is co-owned by the other person, including lesser Majiz Uddin Ahmed, my lord, and there was no NOC by the co-partners, my lord. And plot of land is unpartitioned. The land is not partitioned as of yet, my lord. Lease is executed only with Mazid Uddin Ahmed, my lord, not with the petitioner. Lease has to be executed with all co-owners as per the brochure, my lord, which is why the IOCL has cancelled this application, my lord, because the primary reason is, my lord, there was no NOC from the co-partners, my lord. And on the day of verification, because he was not selected, my lord, he was just asked to deposit the initial 50,000 rupees on the subject that if the original documents matches what you have uploaded in the portal, then he will be allotted with the further process, my lord. But on the day of verification, his originals were, my lord, misplaced. His originals didn't match. So that is the primary reason, my lord, because IOCL cannot proceed with the process if, my lord, the records are not exactly what needs to be done. So which is why, my lord, his application was cancelled, my lord.
So now on 7th of July, you were asked the other party, other.
My lord, it is a fresh lot, my lord. They
Fresh
can
lot.
participate. There is no harm in that.
My lord, whether they had asked me to make alternate arrangement or not, my lord, that 90 days, my lord. And
But
moreover,
what
my
is
lord,
the bar if you can also participate in
No, my
the
lord, because-
draw of fresh lot?
no, my lord, they have already initiated draw, my lord. Since, my lord, they have not communicated, I had came to know subsequently, my lord. And since the draw has already concluded, my lord, kindly come to us page 131, my lord, for a moment, my lord. Here, my lord, this certificate was issued by the circle officer, my lord. It certified that Mufizuddin Ahmed, son of Abdur Rahman of village Galia under Bhawanipur Moza, is possessing a plot of land measuring 1 bigha 4 kata, covered by tag number 451 under KP Pata number 218 of the village Galia under Bhawanipur Moza. That was certified by the circle officer himself, my lord. And kindly come to my lease, that lease, deed of lease, my lord, page 109, my lord, which I have submitted before the ICL, my lord.
No, this is certificate for one Mofizuddin.
Yes, ma'am, for Mofizuddin. And I had, my lord, obtained the land on lease from Mofizuddin, my lord. And that kindly come to page 109, my lord, the lease deed, my lord.
See, we don't have
There
much
is
time,
no
huh?
dispute at all, my lord.
Hmm?
If there is no dispute at all, only, my lord, what happened, my lord, even if, my lord, they are not satisfied with the land, my lord, they could have asked me to make alternate arrangement, my lord. I was ready. But instead of giving that as per their own tender
No,
document,
you have submitted that you were selected as a, whether there is any documents you have furnished yet?
my lord.
You have
Yes, my lord,
selected
this-
in the
this
process,
is
you have
the-
selected. Where is the proceeding?
Yes, my lord. Provisional selection, my lord.
Where?
My lord. Family. Page, my lord, 114, my lord. And operating person 115, my lord. Next page, my lord. Name of location from Bhawanipur. Subject result of draw of lots for retail outlet. Dealership. Intimation of selection, my lord. Your lordship got the 115, my lord.
There is a line which I would like to point out, my lord. My lord, it is written here that this is only a preliminary intimation towards your provisional selection for retail outlet dealership. However, the award of the dealership is subject to the compliance of terms and condition of the corporation in this regard. The terms and conditions were not complied, my lord. The first is NOC was not granted by the co-partners, and the second was, my lord, the originals didn't match with the documents which were submitted by the petitioner, my lord. So the terms and conditions didn't match at all, man.
And that is exactly wrong submission, my lord, because as per my close, my lord, page close 6, my lord, that land document, my lord, page 23, my lord. Here, my lord, I am repeatedly saying, my lord, 90 days time, my lord. That is their own provision, my lord, of their own tender document, my lord. How they can deprive me from this close, my lord?
No, 90 days from after selection, I think,
Yes,
whether
ma'am.
it is after provisional selection.
No, man.
No, my lord, after my
After
lord,
selection.
if I am not cancelled, my lord, if till
Yes,
the
yes, where is your 90 days again? I say 90 days was
my lord, where they
In
have
page?
given me cancellation, my lord.
regarding 90 days time. Where it was?
My lord, 90 days, my lord, page 23, my lord.
Page 23.
Yes, my lord.
Yes.
And the cancellation was done on, my lord, 23 of June, my lord. That was intimated on 23rd of June 2025, my lord. Page 125, my lord. It's very clear, my lord. In case land
Now see, in case of offered, all the applicants under group 1 and group 2
Yes, my lord.
is found suitable, is found not suitable
Not
or
fit.
not meeting the requirements,
My lord.
then these applicants under group A1 and group 2, along with applicants under group 3, who did not offer the land along with the application,
Would
would be advised by the OMGC to provide suitable land in the aforesaid location stretch within a period of 90 days.
Within
That
a
is
period
the
of-
initial.
My lord.
You are provisionally asked, you are provisionally selected, and thereafter you should given a 90 days time for your production of
Yes.
all these documents. That 90 days has already been over. You have produced the documents on verification. It was found that land documents are not proper. I mean, not tally with the other. In that case, it was cancelled, and then there was no NOC. These are the things for which those were cancelled. So this 90 days is prior to your this furnishing of those documents. But after furnishing of the documents, there is no such
After
things, I think.
only, my lord, what happened, my lord, in this case, my lord? I have submitted certain documents, my lord. Until and unless I come to know that that is cancelled, that is not admitted, then, my lord, how can I know, my lord, that will be not accepted, my lord? Because that cancellation was done on.
So now at this stage, your this opening of lot is on 7th of July.
Yes, my lord.
Yes,
My
totally.
submission is very limited. Your lordship must have seen the, my lord, the order which has been impugned. My lord, the petitioner.
Order is a page?
My lord, 125.
Yes, yes, 125. Yes.
Relevant 126.
Yes.
Your lordship finds, my lord, that the procedure is in, my lord, IOC, is that, my lord, on the basis of the documents they submit at the time of filing the application, then, my lord, it is processed and he was found eligible and he was called for the draw, because that is settled by draw only, and he was selected. Thereafter, my lord, field verification takes place. On the basis of field verification, my lord, the final decision is taken. If your lordship comes to page 126, your lordship will find the reason why, my lord, his candidature has been rejected. Serial number 2, page 126. Please also refer to our letter dated so-and-so and letter wherein you were advised to be present personally for field verification of credentials by our officers. This is to inform you that during the field verification credentials, you fail to produce the original documents for verification by the officers. The documents produced by you were at variance with the documents submitted, information given in the application. Then as per Atta's Jamabandi of land, the offered land is co-owned by other persons, including lesser Mafizuddin Ahmed, and the plot of land is unpartitioned. Lease is executed only with Mafizuddin Ahmed. Lease has to be executed with all the co-owners. So, my lord, the documents is not proper. And thereafter, my lord, after cancellation of his candidature, we are holding my lord, fresh the draw of lots among the other eligible candidates. So that
No,
is
one
fixed on
candidate
7th.
has already been selected as per him.
No,
The draw, yes, my lord.
it cannot be because we are holding it on 7th.
My lord, yes, my lord, here,
Okay, for me,
kindly come to page 135, my lord.
Page?
135. My lord,
The selection will be
please-
only after holding of
please,
the draw of lots.
refer under application so and so.
No,
We
you
are
are
pleased to-
qualified for draw of
Draw
lots.
of lots.
We are pleased to inform you that you
Ah.
have qualified to draw lots for selection of RO dealership.
That he is not
Qualified.
So many
selected.
candidates have gone like this.
You are requested to present personally along with photo identity card issued by the any other government on 7th July 2024 for the following Guwahati Division Office so and so so and so. Please note the will not reimburse.
So no selection will be held only on 7th. Therefore, perhaps, my lord, what I am submitting, ladies' interest will also be protected. Let us hold the draw of lots, but we will not issue letter of intent to anyone without leave of the court. That will protect him also.
My lord.
Fair enough. That may be one.
Fair enough. my lord.
Heard Mr. S.H. Sigda, Legal Counsel for the petition. And also heard Mr. M.K. Chaudhary, Legal Senior Advocate. You're standing counsel IUC.
I'll be standing,
Senior Standing Counsel IUC, assisted by
MM Kashyap.
M.M. Kashyap, produced respondent. বাকিখিনি লিখিব। This is an application under Article so and so. Challenging the email dated 23/06/2025 issued by the respondent authorities informing about the cancellation of the candidature of the present petition. It is submitted by Mr. Sigda that he was in person to advertisement dated 28/06/2023 issued by IOC Limited. The present petitioner also applied for the establishment of retail outlet dealership in the location of from Bhubanipur traffic point to Howli traffic point. And accordingly, he was also selected in the process. And in person to that, he also identified the land and the agreement was, you have entered into an agreement also, no?
Yes, ma'am.
This agreement.
No agreement.
It's lease.
No, he.
It's submitted lease.
Agreement with one person out of, my lord, many
Yes,
co-owners.
co-partners. Entered in agreement and agreement also after obtaining the NOC from the concerned department, but suddenly without any information, his candidature has been cancelled by the authority, state authority, respondent authority. But he submitted that the all formalities were observed by the present petitioner while furnishing the documents before the authority. However, it was only rejected on the ground that the co-partners have not issued the NOC to that regard. He further submitted that one candidate has already been selected and the draw of lots for selection of the dealership will be
held on 7th July.
will be held on 7th July 2025. Accordingly, he submitted that he may be, the petitioner may be granted with some interim relief and till the disposal of the present application. And to that extent, it is submitted that the respondent authority may be the respondent, sorry, draw of lots scheduled to be held on 7/7/2025 may be stayed till the disposal of this petition for the interest of the justice. Stop. Next para. Mr. Chaudhary, the learned senior advocate of Standing Counsel, IUC, submitted in this regard that he was only provisionally selected and asked to submit his land documents, but at the time of verification of the land documents, it was seen that he failed to produce all the original documents for verification by the officers, and the documents produced by the petitioner were at variance with the documents submitted oblique information given in the application. Apart from that, it was also observed that the lease agreement was between the petitioner and one leaser, namely Mofizuddin Ahmed. Though there are other co-partners and without any NOC from the other co-partners, the lease agreement was executed. Mr. Chaudhary further submitted that till that there is no selection of the candidate. However, it was fixed, the date was fixed for draw of lots on 7th of July 2025. So and so. Next part, considering the interest submission made by learned counsel for both sides and also considering the circumstances of this case. You are filing any written?
We will be filing our affidavit, but in the meantime, your worship may say that we may proceed with the selection, but no final order will be issued without legal the.
Will file their written affidavit. However, at the interim, the process of the lot will be there. Selection of the
process of selection will be allowed go on, but no final order.
Process of selection of lots may be conducted by the respondent authority. However, the result.
My lord,
or
without legal the court, we will not issue the letter of below.
Yes. But without informing the court, the respondent authority will not issue any letter of LOI.
Letter of intent.
Letter of intent. It's LOI. Yes. It can be fixed at the end of July, last week of July.
Right.
List the matter accordingly on the last week of July as on the date to be fixed by the registry. Okay.
Hello.
Yes.
May I please as your lordships? My lord, a notice of my lord demolition cum eviction is under challenge, my lord. My lord may be pleased to find the impugned notice, my lord, which we have annexed is at page 24, my lord.
Who is appearing?
My lord, the revenue and the governor, the Assam is there, my lord.
You are appearing, Father Sajid?
Yes, sir, I'm appearing.
My lord, in this notice at page 24, this is a page 24, my lord. This is a blanket notice not issued to any specific individual, my lord. May I read over the notice, my lord? To honorable public, it is hereby to inform you that for the ongoing construction works in the road that passes through the middle of Doboka town, the people residing in both sides of the road, which have been demarcated for the Assam Mala and Assam Gaurav project,
and who have created obstruction in the works of the Public Works Roads Department are directed to remove all belongings, things, movable and immovable property within today, 27th of June, 2025 itself. And my lord may kindly note the date and time they have provided, my lords. And to cooperate in the works of the Public Works Roads Department. Otherwise, at any time, the district administration may remove all the movable, immovable property by evicting them, and for that no any compensation would be paid. My lord, this is a notice which is, my lord, has violated all the provisions of the law. That apart, my lord, this is a high-handed exercise of power. Why I am telling, my lord, why I am respectfully submitting, my lord, because my lord may kindly have note the date. This is, they have said that within today, that is on 27th of June, 2025, my lord, we should remove all our pakka buildings, infrastructure, shops, business establishment, whatever we have, my lord, within one day. My lord, for the human being, my lord, if machineries are also involved, I don't think so, it can be done. So therefore, my lord, they have said that if you are not going to do, then, my lord, the district administration may remove the so-and-so by eviction, by following the process of evicting. Now, my lord, what has happened, my lordship has also gone through, my lord, and while we passes through, my lord, in the Upper Assam districts, my lord, we have seen that the both sides of the roads, my lord, have been wide enough for the 4-lane, my lord. And the beautiful buildings are also coming up for the residential purposes also, my lord. Earlier it was not there. Those buildings has been funded by the compensation amount which has been paid by the National Highway Authorities Limited, my lord. But unfortunately, my lord, in this case, in our case, till date, not a single paisa had been paid, my lord. Not a single amount of compensation had been paid, which itself reflect from their letter, from the notice itself, my lord, because they have said by evicting them and for that no any compensation would be paid. That means, my lord, we are entitled to the compensation, my lord. Now, the law which is required to be followed, my lord, is very clear. Under the, my lord, the right to fair compensation and transparency in Land Acquisition and Rehabilitation and Resettlement Act of 2013 is there.
ये पैसे लगना fair compensation.
No.
No, yeah. To fair.
My lord can have my book, my lord, for saving the time, my lord, as we are running out, my lord. My lord, may in this, my lord.
Right to fair and transparency.
My lord, I have requested in the morning, my lord.
Oh,
Please,
that should be done. আমরা প্রসিডিউরে উঠবো না কেউ?
Not the. No.
তথাপি আনি থব লাগে যেটা আছে। Record to like.
My lord can peruse only two sections, my lord.
Yes, section.
Section 11, my lord, may kindly see, my lord. There is a procedure for the publication of the initial notice, my lord. As I am not having the book, my lord, I cannot read over it. My lord, I am troubling my lordships, my lord, to go through this section, my lord. It is very clear and explicit, and the rest provisions are also there, and how the compensations are required to be assessed and to be paid is also there, my lord. But here is a case, my lord, what they have done, my lord, no any notice, nothing has been provided, my lord. Only we could come to know, my lord, that when this notice has been issued that our property is going to be acquired, and the, my lord, public works, my lord, and the building and the widening of road, there is no scope that we can obstruct under the law. We cannot obstruct, my lord. For the public, we have to give away. But for that reason, my lord, this right to fair compensation has been enacted. It is a central legislation, my lord, and it is binding on the state of Assam also. For the Assam, my lord, my lordships is well aware, my lord, the state highways and the PWD highways, my lord, which are being widening up. Those are under the, my lord, Assam Mala project, my lord. And the national highways are also under the Bharat Mala project. But while implementing this project, my lord, this right to fair compensation is a statutory prescription which are required to be followed. But in our case, my lord, till date, they have not, my lord, issued any kind of notification that our land is going to be acquired. Even they have said that the demarcation had been done. My lord, as per our instruction, my lord, till date, no any demarcation has also been done. That the how much widening up is going on, how much land, these are our purely patta land, my lord, over which this, my lord, widening up is going to be done. So therefore, my lord, this is a issue that this violation of, my lord, this right to fair compensation act is also there. Secondly, my lord, that the violation of the Article 14 and 21 is also there, because, my lord, there is a discrimination. In some cases, my lord, what they have done, for the same project, my lord, for the same road, we have come to know, my lord, that some persons has been in other areas, my lord, they have been paid, but we have not been paid. Now, my lord, if this has been disturbed, our shops and business establishments are also there. So therefore, my lord, our right to life is also going to be hampered with, my lord. Secondly, my lord, the absence of the statutory authority in notice. Now, my lord, may kindly see the special notice which I have already bring into my lordship's kind notice, my lord, that page 24. My lord, this has been issued by the Chief Executive Officer of the Doboka Municipal Board. Now, my lord, whether the municipal board, without the, my lord, interference of the acquiring authority, that is the district collector or the deputy commissioner, is the absolute authority, my lord, to acquire any kind of land for the purpose of widening of the road also, my lord. But this notice has been issued. Under what provision of law, my lord, this notice has been issued, that is also missing here, my lord. So therefore, my lord, my another limb of argument, my lord, is that with the, my lord, there is an absence in the statutory authority in the notice, my lord. And now my lordship is well aware, my lord, in the recently, the Honorable Apex Court, my lord, has issued a detailed guideline, pan-India guideline, my lord. My lord, I will not troubling my lordships with the entire judgment, my lord, only with the directions part and the guideline which has been issued by the Honorable Apex Court, my lord, which has an operation of the pan-India, my lord. Therefore, my lord, this is also applicable to our state also, my lord. Wherein the, my lord, the direction part, my lord, may be pleased to find. I am reading in paragraph 90, my lord, the last page, my lord, last third number page, my lord, two listers. If my lordship maybe take up 1, 2, 3, 4, 5 number page, my lord, from last. Paragraph 90, my lord. In order to allay the fear in the minds of the citizen with regard to the arbitrary exercise of the power by the officers, officials of the state, we find it necessary to issue the certain direction in exercise of our power under Article 142 of the Constitution. We are also of the view that even after the order of demolition are passed, the affected party needs to be given some time so as to challenge the order of the demolition before an appropriate forum. We are further of the view that even in cases of persons who do not wish to contest the demolition order, sufficient time needs to be given to them to vacate and arrange their affairs. It is not a happy sight to see women, children, and the aged persons dragged to the streets overnight. Heavens would not fall on the authorities if they hold their hands for some period. At the outset, we clarify that this direction will not be applicable if there is an unauthorized structure in any public place, such as the road, street, footpath, abutting railway line, or any river, body, or water bodies, and also to cases where there is an order of demolition made by a court of law. Now, my lord, this notice part is important, my lord. Notice. No demolition should be carried out without a prior so-called notice returnable either in accordance with the time provided by the local municipal laws or within 15 days time from the date of service of such notice, whichever is later. Now, my lord, may kindly say there is a specific time limit, minimum of 15 days has been provided by the Honorable Apex Court. But in this notice, my lord, how arbitrary, my lord, may kindly say that they remove all belongings, things, movable and immovable property within 2 days. That is, my lord, 27. My lord, this is absolutely a clear case of contempt of this honorable court's, my lord, direction. I should not say the content, but they have willfully has not, my lord, followed these guidelines. So, my lord, therefore, this guideline cannot stand the touchstones of the scrutiny of the law, my lord. So therefore, my lordships, at this stage, my lord, what I can expect, my lord, and what I humbly beg to pray, my lord, that the notice may be issued, my lord, and this notice, operation of this notice may be, is required to be stayed, my lord.
Yes.
Lordship, first of all, the petitioners, they are claiming here their patta land lordship. But none of the petitioner has attached any of the land documents when land documents, all the documents are available online nowadays, lordship. They cannot take plea that within a time they cannot obtain the certified copy. First one. Then second line, all surveys were done much before lordship. There is nothing that this cause of action has arose, lordship. It is already over. And thirdly, lordship, this land is fully government land, lordship. Fully government land, lordship. And even if there is any shops or anything is there, lordship, nothing is of any permanent structure, lordship. The inhabitants are much away, from the far away from the proposed land, lordship. This is there. And there another thing, lordship. They have prayed, lordship, that there, if your lordship may kindly peruse page 23, lordship. They have prayed for, they made an application, lordship, before the authority. I'm just reading for your lordship. সন্ধানভাৱে আপোনাক জনাও যে মই 604 বাসিন্দা হওঁ ডবকা টাউনৰ কিসামৰ অমুক কাষেদি যিটো আসাম মালা ৰাস্তা গৈ আছে উল্লেখিত মাটি ডবকা চক্ৰ বিষয়া অফিসত মোৰ নিজা দখলীয় মাটিৰ চাৰিসীমা নিৰ্ধাৰণৰ কাৰণে আবেদন কৰিছো ৰাস্তাৰ মাটি আৰু মোৰ নিজা দখলীয় মাটিৰ নিৰ্মাণ নোহোৱালৈকে পৰা নলা কাম নকৰাৰ বাবে আবেদন জনালো And in the translation, they have stated, I have the honor to inform you that I am a local resident of the Doboka town. Now roads is being constructed near land under patta number so-and-so. Doboka railway town Kisam under Assam Mala project. Therefore, I have applied before the circle officer Doboka circle for demarcation of the boundary of my aforesaid Miadi land. And here it is Dokholio Mati. Lordship, kindly, I have not interrupted.
Please.
So this is their lordship and the municipal board because they already the measurement has been done, everything has been done, lordship. Suddenly they have come up and obstructing the project, lordship, which is in full swing, lordship. And there are various judgments of the honorable court that public interest is always get the prevails over the private interest, lordship. So here once and another thing, lordship, they are seeking about telling about compensation and all these things, lordship. When it is a government land, there is nowhere no judgment of any of the court that the government who are, that means occupying the government land, they should be compensated fully, lordship. This is their lordship. So my humble prayer is that this is some simply an afterthought on the part of the petitioners. They just want to stall the progression, lordship, stall the project. And for hampering this, they are before the honorable court. So I humbly pray that the prayer that has been made, lordship, this should be rejected, lordship.
My lord, may I clarify, my lord? My lord, if my lord may be pleased to take up my petition, my lord, I am troubling, my lord, the page 7, paragraph 2. Paragraph 2, my lord, that the petitioners humbly beg to submit before this honorable court that they have been the permanent resident of a Miadi Patta land in the Doboka railway town village under the Jamunamuk Moja in the Doboka revenue circle in the district of Huzai area in the plots of land mentioned in the table below under.
Now, as per them, it is a Miadi land, isn't it? As per your information, it's a purely government land.
No. My lord, my lord, if it is a government land, my lord, we cannot make any claim. And my learned friend's allegation that we want to stall the project, my lord, how we will be benefited by stalling the project, my lord? Our only limited prayer, my lord, is that there should be a proper demarcation. And after the demarcation, if our Miadi land is used, and if our infrastructure and the buildings fall within the Miadi land, my lord, then only we are entitled for the compensation. That exercise they have not carried out. Only when this notice has been issued, my lord, what they have done before this notice on paper or notifying or issuing any kind of document, that is not available, my lord. Now, my lord, only thing
How
is
you're
that.
saying that this exercise is going on, in fact, since not on, it is not the case of that the notice was only issued on 27, but there was an exercise of.
Yes,
all
the
this-
exercise has already been completed, lordship. Now they have,
What is those documents? What are those instructions?
they can, yes, and notice itself speaks about this, lordship.
No,
If your
notice.
lordship. Kindly
My
allow
lord,
me
my
to
lord,
submit.
my lord, the notice, the
If
language
they
of the
continue-
notice. No, my lord, I am not obstructing my respected senior friend. Let her complete, my lord, but I will satisfy my lord, my lord, regarding how arbitrarily they are doing. My lord, even we assume that my lord, we are occupying the government land, then can my learned friend say that this, my lord, notification as regards the guideline, Pan India guideline, which has been issued by the Honorable Apex Court is not applicable, my lord? That is the issue, my lord.
Bhattacharya, just tell me one thing. Obviously, if it is in government land, question of compensation may not arise. But now they are claiming that this land is of Miadi land, and if any construction is there, definitely there may be a question of, there may be a.
Lordship.
No. Then in that case, they may entitle for compensation. But the question is that they are challenging this notification, which was issued on 27/6/2025. With the that the all the removal and all has to be done carried out within 2 days.
Lordship,
Whether you can
kindly peruse for a moment page 25, the vernacular portion of the notice that has been served, lordship. The general notice. ইয়াৰ দ্বাৰা জনোৱা যায় যে ডবকা চহৰৰ মাজে বৰ্তমান চলি থকা অসমমালা আৰু অসম গৌৰৱ পথৰ বাবে সীমা চিনাক্ত কৰা দুয়ো কাষত যিসকল লোকে সীমা চিনাক্ত কৰা, it's already carried out, lordship. Sima Sinakta Kora. Demarcation has already been done, lordship. It is not that the road is progressing. It has been done at 2-3 years back, lordship. It is not that this is on 2-3 days this has been done, lordship. Because when a project is taken up, lordship, it is before implementation, the much things are done much before, lordship. So it is not. This is their lordship. Sinakta kora duo kakhot jiসকল লোকে বস্তু বাহানি স্থাবৰ অস্থাবৰ সম্পত্তি ৰাখি লোক নিৰ্মাণ বিভাগৰ কামত বাধা সৃষ্টি কৰিছে. So these are intentional, lordship. As the lane is progressing, it is not that this has been acquired only in this month and the road is progressing. This is not so, lordship.
My lord,
This is all done. Kindly allow me to, okay. You will have enough time to rebut this.
No, we don't have time.
That's it.
So this is my humble prayer, lordship. The vernacular portion is totally clear, lordship, that this demarcation has already been taken place, lordship. So these are now only, they are just obstructing the project to go smoothly, lordship. This is there. And there is no question that these are all the other Miadi Patta land. If it is their lordship, process has already been taken.
Oh, yes.
They will not be singled out.
My lord, I am not troubling my lordships with the much time, my lord. As we are, my lord.
Any what submission you want to submit?
No, my lord,
What
if my lord is going to provide me interim, my lord, I am not going to, my lord. This notice is.
May not be questioned.
Lordship, interim cannot be.
No, my lord, the issue, my lord, this notice is not at all sustainable, my lord. My lord, may kindly appreciate that on the same day, is it, and my lord, this is the language of the notice, my lord. Kindly appreciate.
No, if you go by the SMS version, it speaks otherwise.
No, my lord.
Translation is a bit different.
My lord, I am
in two matters, we have seen the translation in 22 and 23 translation simply differs.
Yeah.
And in 24 and 25 also translation is very, I mean, I don't know whether it's intentional. or
As the vernacular is already there, my lord, is already there. There is no question of misleading my lordships, my lord. My lord, may kindly peruse the vernacular one, my lord. ইয়াৰ দ্বাৰা জনোৱা যায় যে ডবকা চহৰৰ মাজত বৰ্তমান চলি থকা অসম মালা আৰু অসম গোবৰ পথৰ বাবে চিনাক্ত কৰি দিয়া কাষত যিসকল লোকে বস্তু বাহিনী স্থাৱৰ আস্থাৱৰ সম্পত্তি ৰাখি লোক নিৰ্মাণ বিভাগৰ কামত বাধা সৃষ্টি কৰিছে সেইসকলে আজি ইংৰাজী 27 জুন তাৰিখৰ ভিতৰত সকলো সামগ্ৰী স্বত্ব ইত্যাদি আঁতৰাই নি লোক নিৰ্মাণ বিভাগৰ কাম কৰাৰ ক্ষেত্ৰত সহযোগিতা কৰাৰ বাবে আদেশ দিয়া হ'ল। My lord, they have said they have already demarcated, but no demarcation has been done. If demarcation is there, my lord, then we cannot object anything, my lord. Now they are suddenly coming, my lord, and demolishing our house on the same day. My lord, this is not absolutely arbitrary, my lord. This, my lordship's interference is very much warranted. Let them come up with an affidavit, my lord. On the next day, let them come up with an affidavit and with all the documents and notification. My respected friend has said, my lord, that they have done it since long. What exercise they have carried out? Where is the record of those demarcations, my lord? Those are required to be placed before my lord, my lord.
This is separate thing, lordship.
No
Let them
separate, my
prove
lord.
that
This is not a
their
one
land,
separate, my lord.
lordship.
This
That is
is,
their
my lord,
documents,
if it
lordship,
is,
when it is
my lord, may
everything
kindly
on the
appreciate.
portal, lordship.
No, my lord, may kindly appreciate, my lord. I have all the annexures, my lord, as it is in vernacular, my lord, with our patta record, my lord. If beyond this patta land, my lord, if any land is taken from us, my lord, we do not have any claim. But if there is, unfortunately, my lord, any structure is there, my lord, that at least 2 days, 15 days time is required to be given, my lord, to remove all these things. My lord, may kindly see in the same day, 27 জুন তাৰিখৰ ভিতৰত সকলো সামগ্ৰী স্বত্ব ইত্যাদি আঁতৰাই নি লোক নিৰ্মাণ বিভাগৰ কাম কৰাৰ ক্ষেত্ৰত সহযোগিতা কৰাৰ বাবে আহ্বান। My lord, is it possible for human being, my lord, to remove all this permanent structure on the same day, my lord? This is a high-handed exercise of power, my lord. So therefore, my lord, this notice is required to be suspended for a moment, my lord.
Yeah, the learned counsel for the petition. And also heard MS Arbirtrary, the learned. Your
I'm appearing for respondent number. I'm appearing, the other,
you're appearing for now, respondent number.
Respondent number 3.
Your
for respondent number 1. 1, I am appearing, lordship, then the respondent number 7, 8, 9, 10, and 11.
1, 7, 8, 9, 10, 11. And
I'm appearing for respondent number 4. Six.
So you are appearing the strength of
PW.
PWD, standing counsel PWD 2, 3, 2, 4, 5. How many?
6.
2, 4, 5, and 6.
And for 3.
You are for 3. 3.
172.
Sense, huh? This is an application under Article 2, so and so. Submitting the legality and validity of impure notice of eviction dated 27/6/2025 issued by the Topoka Municipal Board by reference number DMB 27/2025/3167. It is submitted by Mr. Vuya, the learned counsel for the petitioner, that the petitioners are the landholder of the Miadi landholder of the Miadi landholder, wherein the project of Assam Mala and Assam Gorok is being carried out, but without any proper demarcation of their land and without any notice for competition or eviction. A special notice was published on 27/06/2025, directing the petitioners to remove all the belongings, things movable and immovable, within 27 June of 2025 itself and to itself, which is purely an arbitrary exercise by the department, the state authorities. Full stop. Further, he submitted that in the similarly situated person, wherein also the Miadi land has been acquired, were already sanctioned with proper compensation. But for the present petitioners, there is no any assessment of their compensation nor any proper demarcation of the land was carried out by the government department. Full stop. In that context, Mr. Bhuya further relied on a decision of Honorable Supreme Court passed in reported in 2024 SCC online SC 3291, wherein also the Honorable Supreme Court had given some guideline for eviction. For eviction and wherein it has been held that the order of, even if there is an order of demolition is passed, the affected party needs to be given some time so as to challenge the order of demolition before any appropriate forum. Accordingly, he submitted that the as an interim, the notice may be issued to the other side, but as an interim, the impugn notice dated so and so 27/06/2025 may be stay or suspended till the disposal of the present writ petition.
Or may not till the returnable date, my lord.
Or till the returnable date. Next para. MS Faraj Chachi, the learned senior government advocate appearing for so and so, submitted in this regard that from the notification itself, it is very much clear that the land of the present petitioners had already been demarcated and the construction of the Assam Mala and some Mala and some Gaurav is already been carried out, and hence question of demarcation at this stage does not arise. However, the petitioners are obstructing the progress of the work, and for which the notice had to be issued by the government authorities for removal of their movable and immovable. Full stop. She further submitted that as per instructions, these petitioners are also not near the landholder and they are occupying the government land, wherein the question of the compensation also does not arise. Accordingly, she submitted that the present petition is not maintainable and it may be dismissed or rejected. Next para, considering the entire submission made by learned counsel for both sides, it is seen that the eviction notice was issued on 27/06/2025, directing the petitioners to remove their all belongings, including movable and immovable, and also directed not to obstruct the progress of the work of Assam Mala and Assam Gaurav. But from the notice, it is seen that the petitioners were not allowed even a single day for removal of these obstructions as alleged by obstructions which were kept to remove the alleged obstructions from the area, and the notice is one submission was also from your side that there was no who issued the notice, authority.
My lord, the statutory authority is, my lord, under what authority, what provision of law, that is also not here.
It is also seen that the door notice was, the eviction there's no any provisional authority or provision under which the said special notice was issued by the state authority. Considering all these aspects of the case, this court is of opinion that the impugned eviction notice dated 27/06/2025 may be operation of so and so may be stayed or suspended till returnable date, enabling the state authorities to file their written affidavit, at least the matter immediately after vacation or on 10th.
One more thing, Lordship. If your Lordship is allowing the interim prayer Lordship, then the specific their particular Meadi land Lordship, not beyond that.
No, this notice will always operate on the Meadi land.
Yes, Lord. Not beyond that, Lord.
The stay to diok only subject
Pata numbers are there, Lordship kindly.
only subject to the notice.
Paragraph 2, it is mentioned, Lordship kindly mention the Pata number, Lordship.
Only in respect of the
Pata number mentioned.
Meadi land.
In page 8, Lordship, paragraph.
My lord, can record the page number 8, my lord.
Yes.
Only
this
in
detail.
respect of
Yes.
for the patta and dag number as mentioned in para 2 of the petition.
Petition.
So immediately after vacation it will be
Right.
fixed until returnable date on which it will be stayed.
20.
15 can be after vacation. 57.
Lord, I will be on medical, some issues. Lord, can it be on
Lordship,
26?
that will also be there, Lordship. We will
26.
file our affidavit.
You can file your affidavit.
Yes, Lordship.
Can it be on 22nd or 24th July?
Okay, 22nd.
Mark.
It will take a
Oblige, Lord. File your oblige.
Till returnable date.
Till returnable date. Till return.
Item number 16.
I'll take 1 minute.
Why bail hearing is also here? It's a motion. Was it an urgent matter?
1 minute,
Yes.
sir. 1 minute subject.
Yes.
Page 19, my lord, for a 1 minute.
No, 1 minute submission from you because what is
No,
happening, in fact,
yes.
I'm leaving tomorrow. They are also leaving tonight itself.
Because
So we don't have any time for
Yeah,
correction
yeah.
and uploading orders and all. That is the main
only,
issue.
only the thing is that, my lord, there are two accused, my lord, page 19, my lord. One has page 19 for a 1 minute.
Nineteen.
19, my lord. There are two names, my lord. Asimuddin and Abu Syed Khan, my lord. Lordship found, my lord. My lord, that Abu Syed Khan, my lord, that Lordship had allowed his bail, my lord. Same order, my lord. Here, my lord, in that order, my lord, paragraph 5, my lord. The Lordship will find, my lord, the petitioner got arrested, my lord, on 12/1/22. Instead of 8/3, my lord, it should be, my lord, 12/1/22. And since last 3 years, 5 months, my lord. 3 years, 6 months, my lord. And, my lord, in case of 3 witnesses, my lord, it is 4 witnesses out of 10. That much, my lord. Out of 10, 4. And in paragraph 19, my lord, there will be one correction, my lord. There is 3 years, 2 months, my lord. It will be 3 years, 5 months, my lord, 23 days, 25 days.
20?
19, my lord. Sorry, paragraph 19, my lord. There it is written, my lord, 3 years, 2 months, my lord. It will be 3 years, 5 months, 25 days. That much more.
Lordship, regarding Parity, Lordship, contraband was not recovered from him, Lordship.
Other one.
Yes, Lordship. Here, Lordship, contraband recovered from the position of the petitioner, Lordship. So regarding Parity, I am submitting this judgment, Lordship, number 11. And Lordship, regarding delay, Lordship, from last 2 days, Lordship, seizing officer appeared, Lordship, but Lordship, opposite counsel for the accused person was not there, Lordship. So I have the order of last order of 10/6/25.
10/6/25.
Record is not there, and it is not there in the record, Lordship.
So, Lordship.
You have finished your.
From last 2 dates, Lordship, seizing officer was there, Lordship.
My submission, prolonged incarceration and 50 notice.
But it could not be recorded due to absence of the other side.
Yes, Lordship. This is the order.
The submission before. In the submitted that the ground of parity cannot be applicable in the case of present petitioner, as the contravent was recovered directly from the present petitioner, though it was not recovered from the conscious position of the co-accused. Act number, due number submission before, but it is submitted that the seizing officer is appearing before the court in 2 occasions, but due to absence of the learned defense counsel, he could not be examined. And full stop. MS Deca, A2 Diva in here, which one you are?
Rajesh Ranjan, para number 17.
Rajesh Ranjan, para 17.
17.
Pada MS Deca submitted that as relied on a decision of Honorable Supreme Court. Passed in case of Rajesh Ranjan, alias Papu Yadav, bracket of Supradipa, and basically emphasized on para 17 of the said judgment, wherein 17. You're basically, this one is for law or law on parity, isn't it?
No, this is.
It is not on parity. Oh, then it's okay. Etu agote amar tate dia ase tanoke etu relay kori dibo. Other one is parity on parity.
On parity, Lordship.
Acha, this is para 11.
Para 11.
Etu agote dibo relay kora boli aru etu para next to jitu moi di asu Supreme Court other one etu must mark kori disu. Next mark kori tare para 11. Submitted that in the regard of ground of parity, she relied on so and so in para 11. Para 11. When it is expressed the view that the ground of parity cannot be considered if the footings of the case are entirely different. Okay, rest I'll pass you on.
The next item 17, my friend has brought, I'm not today, after the 17. After the
Etu yaar logote ase na yapa dile homa correction kira kori thoi disu. So other one you're not pressing now?
After vacation.
Oh.
After.
17 to list after vacation. Oh.
I'm sorry, my lord. I didn't have lunch also today.
You have not, you haven't taken your lunch?
No, my lord. Today he brought me when I
Actually, in division bench, we took some time. In fact, by 12:20 only it was there. And then again, I started here from 12:25 or 12:23 something. So that's why it was delayed, in fact. Otherwise, 21 and the read petitions are also some time, in fact. That's why.
I'm obliged.
Oh.
May I please, Your Lordship?
Is there any urgency, first of all, tell us? Because bail hearing, we are not taking, in fact. It was not supposed to take the bail hearing. When your petitioner is in custody, since when?
12, today is 49 days.
49 days. It's a case of what kind of case?
Withdraw this petition.
You want to withdraw this one? Okay. As per instructions?
Yes, as per instruction.
Your good name?
R. Islam.
R. Islam. Heard Mr. R. Islam, the learned counsel for the petitioner. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Islam that as per instructions of his client, he wants to withdraw the same. If we have disposed of withdrawal. Okay, it will dispose of.
In the earlier case also, the case diary was there. Actually, retained the case diary.
In 17, item number 17, retain the case diary. When it can be fixed on? After vacation? Yes.
Wait, please, Your Lordship. Your Lordship, 19 year.
Ahmed, I'm not going to hear, in fact. What is the urgency was just tell us?
Your Lordship, that 19-year-old student, Lordship, and he posted one comment in the Facebook, and because of that, he is in custody.
So we have received the case diary here.
The scan copy was
Scan copy was called, and there was liberty was given to us that if you can make mention before the vacation court, because Lordship, that on that day, that
Sorry.
records were not there. Therefore, in the order, it is written that on or before 14th record were called. On or before what was
It is 14/7.
On or before, Lordship. Therefore, on or before was mentioned, and we are.
It is a charge sheeted case.
Charge sheeted case. Already charge sheet is submitted, trial is pending, Lordship. So,
Okay, immediately list. You have received the PCR?
as per my,
Don't say LCR now, PCR.
TCR, Lordship.
as per my instruction, Lordship, PCR received, Lordship, as my ladder client has verified from the registry, Lordship.
Okay.
Today they have received. So may I pay over 10th, Lordship?
Actually, I'm in that view that I also don't want to put burden on the vacation code. But 3 judges are there, I think.
Posting
3.
that, Lordship, that I love Pakistan, because of that he is in custody. For that, whether his custodial detention is required or not, only that much, Lordship. Because
10th, you are okay then 10th COVID of Nigel. Okay, 10th we are listing it on 10th. List on 10th before vacation.
always. It is not at my last occasion, this honorable court passed order fixing to the my lord. Is the reason the matter has come up. And everything is complete.
Why you are fixed police vacation venture? Why there's been fixed? Because we are not in a, that should not be fixed, in fact. Anyway, your petitioner is behind the bar since when?
I'm behind the bar since last 14th of June, and
14th of June.
I was suspended immediately after arrest. I was thoroughly interrogated with 3 days police custody, and today I am in judicial custody. I mean, no point keeping me in the police for 16 days. 16 days too.
You have not received the case diary yet.
You have not received the case diary. Where the intimation was good there?
Intimation was earlier, the intimation was there. He is on another duty. That's why he is unable to produce the case diary.
Because in the first day, there was the order of 24/6.
Because
Then matter was listed again on 27/6. So it was, date was very short, I think. Na?
Intimation was made on 26/6 that he was unable to produce the case diary. It was very short period.
আমার প্রত্যেকটা কেস না আমার তিনজন জজ আছে কোন কোন আছে জানেন কি রেজাল্ট আসেনি তিনজন আছে probability of listing বহুত বেশি to come to point. Okay, I just talked to 3 judges will be there on 10th. Considering your
Let it come up after vacation.
after vacation.
That will be better, my lord. Unnecessarily again another day I will sit from morning till 4 o'clock.
I have seen you. That's why I was supposed to ask you what is your matter. I didn't think that generally you do some civil matters. Nah. That's why I thought that your petition, your case may be either maybe read petition and all. Then only you have come up with the bail application. Anyway, I have seen you. You are waiting for since morning, in fact.
There are laborers working in my home who is also waiting for me to feed them. It is okay, my lord.
Then only after vacation only?
My lord, let it come after vacation.
When you just made try to make the
15th of July.
15th of positively on 15th going to heard Mr. H. Das, the learned counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned additional BP, appearing on behalf of state respondent. It is submitted by Mr. Goswami that CD not received. And that considering the submission made by so-and-so, let the matter be listed on 15th of July 2025, directing the IO to furnish the case diary on or before the next date of listing without fail. Okay, then we'll list.
Item 21.
Currently time to page 11
of the IF.
I'm not going to hear anything. Anyway, what is the position? What is the IF for, in fact?
IF for, my lord, what happened, my lord? We have applied to applied.
Oh, acha.
Because
This
the-
one is for alteration, na?
My lord, for modification.
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 To apply,
to the-
appear before the court who is part the
We
order.
are not allowed but to appear, my lord. That's why, my lord.
We are not?
We are not allowed to appear in the interview.
Not allowed.
Not allowed. That is the, in spite of the order of the this honorable court. Kindly turn to the page 11, my lord. And who is going to
No. You need an alteration too. Modification and alteration.
my lord.
I'm saying that the order has been passed by Justice Kardak, I think. Or who had passed the order?
My lord, yes, my lord. But
I missed-
but my thing is that, my lord, it will be infructuous, my lord, within this week, my lord. That's
No,
why I
modification we cannot touch. Modification cannot be done. You can do one thing. This week, I mean from Monday to Friday, the Arunachal bench is available. From next week only onwards, there will be vacation. So this week you will get a chance.
My
So
lord.
why don't you through online call also you can appear if you want, because this week it is an open day, open week for Arunachal.
I can appear online.
And Mr. Kardak is there in Arunachal.
My lord.
He is dealing singly. He is doing that because other judges are not there, I think. We are also availing holiday. Now, Mr. Kardak will be availing holiday on the next occasion. So, Justice Kardak will be there.
My lord, then record should go there, my lord, then.
No, there's a process. You no need to record. The entire record to be there. This copy, scan copy will be there in the Arunachal bench.
It is already with the filing section available, my lord. Scan copies.
Filing section available. You just made a mention before the filing section,
My
or I can list it.
My lord. My
List before appropriate bench on 5th
lord.
or 6th. It
My
can
lord.
be. Okay, then Resti will do everything.
My lord, kindly fix the date, my
Okay.
lord. When can I-
5th. Aaj ki baat hoise, aaj ki baat kari? 5th तारीख. 5th तारीख. So today is Monday.
My lord,
So
one-
let it be on Thursday. We'll do.
my lord, one urgency is that, my lord.
Thursday or Wednesday.
Today, even today or day after tomorrow, maybe they will complete the appointment because the CDPO is transferred. And within a short notice, my lord, in 48 hours notice, he is going to select and elect and everything done and to get transferred. That is the main thing. my
So
lord. That is the
you want to fix it
as
on
early as
Wednesday?
possible, my lord. Only as early
No,
as
that's what I'm saying. Today is Monday.
Monday.
Let it be on Wednesday then. Okay.
possible. Next time.
Wednesday is 2nd.
Second.
So, list 27, 270 before the appropriate bench.
My lord, make it clear, my lord, that other they will get confused, my lord, what to do, what not to do, my lord. Make it kindly more clear, my lord, for the registry. my lord. Appropriate, but it's.
Appropriate bench and registry will do the needful. That will sufficient. You can approach the registry, make it mention that is a very urgent, and I have already fixed the date.
And you test me the copy, my lord, kindly. It may be mentioned, test me the e-copy there, my lord.
But we are not having holiday. What to do now? Where it is not the Arunachal matter.
No, my lord, it is some matter.
Assam matter now. Then what can be done?
My lord, it is, as far as I know, my lord, when the bench was not available, it can be taken. On last Friday also I mentioned it, my lord, in the morning, in the court, my lord, in the court number 10, my lord. At 2 it was allowed, my lord. But suddenly, my lord, the court had to rise because of the farewell function, my lord. And it did not reach, my lord.
No, alteration is not possible. Yes, only by that court.
My lord.
But how can we fix now this vacation? How can we fix? Huh? No. Can it did or date be fixed? That's what I'm asking. Because it is holiday for Assam. That's why.
তারপরে লিঙ্ক টু লই মানে কৰিব পাৰিব বাট ৰেজিষ্ট্ৰি শুড সেন্ড ইট মিল টু ডু দ্য নিডফুল
Before appropriate bench and considering the submission and considering the urgency of the matter as submitted by your Mr. A.K. Talukder, the land counsel for the petitioner, the registry may take steps to hear the matter from.
Video conferencing.
It's not should not be there, I think. How can it be possible? No, registry is open, but how can we direct the vacation bench to arrange that one? That is the main issue.
My lord, if the copy is sent, the email copy, e-copy is sent there, my lord, and I can make submission from here, from my chamber.
No,
my lord.
submission here otherwise. How can you fix the order?
For years.
How can you say Arunachal bench? It is not a matter of Arunachal. Na?
He can.
Huh?
He can do the VC from here.
How can we do?
Well, otherwise also,
Yes.
if he, my friend, make a mention in the Arunachal bench via VC and the honorable court permits, it can be taken up tomorrow, or it can be taken up on Wednesday, my lord, subject to concern with your registry.
Do one thing. I'll just pass the order list before appropriate bench. You today only you make a mention before the registry. That matter is very urgent, and the Justice Kardak is the appropriate bench or who pass the order. So can we have the hearing of this matter through VC from Arunachal bench, because he is now at Arunachal. As far as my knowledge is concerned, Mr. Kardak is there in Arunachal.
Yes, ma'am. So kindly pass some direction so that I can do it only on my.
How
submission
can I
is-
direction? Direction is the registry will,
registry, ma'am, to registry, ma'am.
appropriate bench. Registry will do the needful. Okay.
Registry, ma'am. No, sir, no.
Mr. Das, you hurriedly go your house and have something.